All right, good morning, everyone. I think we are all assembled. Good morning, Mr. Duncan. You're muted, but we are gathered for the reconvening of Civil Appeal number 11 of 2021, and the appearances are as before. Mr. Duncan.
Thank you, Mr. Coelho. Thank you, my lords. First of all, I'd just like to confirm that the court is in possession of our skeleton argument file today.
Yes.
Thank you, Lord. And so I will be commencing my submissions from that document.
Yeah.
Starting at paragraph 2. Paragraphs 2 and 3 basically are a summary of what this court may have already heard and what the live issues are that remain. So our understanding is that the issues in the appeal are whether, firstly, the Section 1 protection of the law under Section 1A of the Constitution is independently enforceable, and that's what we call that ground. Mm-hmm. Secondly, whether the broad power in Section 7AA infringes the protection of law provision in Section 1A. We call that the rule of law issue for convenience. Thirdly, whether the broad power given to the minister in Section 7AA infringes Section 13.1. We call that the direction issue. And fourthly, whether the Amendment Acts and the Reform Bill infringes Section 13.1 of the Constitution, that we call the control issue. And finally, as we will best try and argue it, whether Section 9.1 of the Constitution is infringed by, and we use removing municipal elections as a shorthand. We'll come to the detail of the ground. We call that the Section 9 issue. So yeah. In terms of our skeleton arguments, we're going to be relying predominantly on this skeleton argument and what we call the rule of law skeleton argument. And we will be relying on it with respect to these outstanding issues. So firstly, if we go to paragraph 4 of the skeleton argument file today, the independent enforcement issue. As we understood the position, the court was interested in understanding whether the Halsbury's exception to, or what appeared to be an exception to the Young and Bristol aeroplane rule, actually would apply with respect to the Great Bay case, the rationale being, as the court had identified, whether or not if on appeal to a higher court, the House of Lords, they made their decision on another ground, that meant that untouched grounds in the Court of Appeal decision were no longer binding authority. And it seems, my lord, paragraph 5 of the skeleton, that the El Madawi case was the reference in Halsbury's, and that reference was a House of Lords reference. And we have the case, my lord. I'm wondering whether you could, the lords could turn the case up at, I think it's newly been uploaded, and I'd ask the court to turn to the reference at page 846.
A moment. Mm.
846.
Wait a minute, I'm trying to find Al Madawi.
Lord, I was informed this morning that the cases had been uploaded with the
Yes,
skeleton.
they are. It's just
Yeah.
that this is a probably unsatisfactory.
They're uploaded, Mr. Duncan, but for my part, they can't be retrieved. They've been sent to us by email, and that presents its own challenges, but I'm sure we'll get there.
My lords, to assist, the relevant passage from the authority is actually extracted and put in the skeleton argument. So if there are difficulties, let's not go through. I can just rely on the skeleton argument. The court has the reference and they can go to the actual case
Yes.
at a more convenient time. My lord, and what the House of Lords says is, I'll just read it because there are a couple of submissions we wish to make based upon it. Macpherson J acted on a concession made by Mr. Panic for the Secretary of State that unless...
Sorry, I have got the actual authority on the screen. So can you tell me where you're going in it, please?
Yes, it's page 846.
Well, the problem about that is, I see.
Page 24, my lady.
Well, I don't, I have the numbers in the text, which is a bit difficult.
At the bottom right-hand corner, you may have a page number 24.
Yeah, it's invisible.
Oh. Okay, if I can then...
We've got the page numbers in the middle of the text. So for example, I've got 881, star 881. So if you just tell me the actual report case, that's fine.
I'm looking now.
I mean, it starts at 88 something, I think.
So if you look at 893,
Thank you, that's fine.
and then go over the page, I couldn't see the page number in the page I'm in. It's the next page after 893. The page should commence when the tribunal giving the decision.
This is in the judgment itself, is it?
That's correct, yes.
Okay. Yeah, and how does the paragraph begin?
On the following page, the paragraph begins, Macpherson J acted on a concession.
Yes, okay, I've got that, thank you.
Yes. So Macpherson J acted on a concession made by Mr. Panic for the Secretary of State that unless he could show personal fault on the part of the respondent, the court was bound by ex parte Romani and should grant the relief claimed. Before the Court of Appeal, this concession was withdrawn and the court accepted a submission. The decision of the Court of Appeal in ex parte Romani was not of binding authority since the House of Lords had decided the case on a different ground and had held that the point of principle decided by the Court of Appeal did not arise. The court, however, went on to reach the same conclusion on the question of principle as had been reached by the Court of Appeal in ex parte Romani for essentially the same reasons. Your Lordship must now decide the question of principle, and the question whether the reasoning of the Court of Appeal in ex parte Romani was technically binding becomes academic. In these circumstances, your Lordships find it not necessary to hear argument on the point raised relating to the application of the doctrine of stare decisis. So, my Lord, what we say is that the House of Lords in this case did not determine, and I'm referencing paragraph 6 of our skeleton argument, the House of Lords did not determine the status of a Court of Appeal judgment in light of a later House of Lords decision that decides the appeal on a different basis. So where that leaves us is that there does not appear to be any House of Lords authority for support of the proposition that we find in Horsbridge. And what is ironic is that when we look at the case of Madawi, it appears that the same principle that my learned friends were seeking to rely upon would apply to the principle in this case, because by virtue of the House of Lords deciding the case on a different principle, it means that the authority in the Court of Appeal is no longer binding. So it would be our submission that for that reason, the Court of Appeal decision and that rationale should be rejected.
Right.
Our next point is this. In any event, the only court binding on this court is the Privy Council, and the case of Attorney General and Christopher at tab 25 of the bundle. That's the original bundle. If I can take you to tab 25. The Attorney General and Christopher makes the point that is, we say, binding on this court. It's the,
Sorry, Mr. Duncan, just repeat the reference for me.
it's the Attorney General,
No, the tab number.
tab number 25,
Thank you.
page 659. Letter D. 659, letter D. Their lordships have been asked by the Attorney General to express their opinion as to whether the Court of Appeal was right in considering itself to be bound by the two previous decisions of that court in the case of Charles and Phillips and Herbert and Phillips. To hold Regulation 3.1 of the Emergency Powers 1967 was invalid. Their lordships considered that the Court of Appeal was right in holding itself to be bound, although their lordships have decided that Regulation 3.1 was valid for the reasons stated in this judgment. Their lordships agree with the decision in Young and Bristol Aeroplane, but save for three exceptions there stated, but which are irrelevant to the present case. The Court of Appeal is bound by its own decisions on points of law. The Court of Appeal in England has never since 1944 departed from that decision, and the House of Lords has frequently endorsed it, firstly in Young versus Bristol Aeroplane itself, and most recently in Farrell versus Alexander. And my lords, I don't know whether you, I know that some of you have hard copies of the authorities and some have electronic, but there is a case at tab 24, the tab before that, Davis and Johnson.
Yeah.
Davis and Johnson was a case in which Lord Denning, with a bank of 5 judges, tried to overturn a previous Court of Appeal decision, and the House of Lords didn't take too kindly to that approach. And at page 328, one of a number of the judicial pronouncements that was made, 328 paragraph D, you can see the emphatic words used by Lord Diplock. In my opinion, this House should take this occasion to reaffirm expressly, unequivocally, and unanimously that the rule laid down in the Bristol Aeroplane case as to stare decisis is still binding on the Court of Appeal. So we submit, Lord, at paragraph 8 of our skeleton argument, that this court should disregard the Hallsbury's exception because Hallsbury's purports to be citing an exception that is not, in fact, in Young and Bristol and the Aeroplane Company. And the Hallsbury's exception was not determined in Al Madawi. So applying the current state of the law and the Young versus Bristol Aeroplane case to this particular trilogy of Court of Appeal cases, the present case in the Privy Council Great Bay declined to deal with the independent enforceability of Section 1 of the Constitution, but that should not impact the reasoning of the Court of Appeal in the Great Bay case. It should also be noted. it should also be noted, if I can ask the court to turn to tab 12, just as an aside in the Inch Cup case.
Yes.
I can ask the court to look at page 5, paragraph 13, the last full paragraph, or the penultimate full paragraph in paragraph 13. Page 5 of that case. Mr. Justice Stuart Smith refers to the case of Lewis, the Privy Council case over which we have had some debate.
I thought there's a problem there because what he refers to is Lewis v. Attorney General 2057 WIR 275, and that is to be found at the immediately following tab, which is tab 13. And that is the decision of the Court of Appeal of Jamaica. What he doesn't refer to is the decision of the Privy Council, which is to be found at tab 35, although the decision of the Privy Council had, I think, been determined before the Court of Appeal in Inchcup.
That's correct. That is correct, Lord.
Now, that's a mistake. Well, it's not a mistake. It's correct that Lewis was a case on the Jamaican Constitution, but the Lewis that he's referring isn't the definitive case.
It isn't the Privy Council judgment, Lord, and I accept that. But for the purposes of our argument and the Hallsbury's exception, we say in paragraph 11 that not only do we have the Great Bay decision, which is now the Court of Appeal decision, which, for want of a better way of putting it, is now reinstated as a binding authority. We have the Inchcup decision, and we can put to one side the reference to Lewis. But we also have Ferguson, and we have confirmed, paragraph 11 of our skeleton argument, that during the course of the hearing in Ferguson, as I said before, all the usual suspects were before the court with respect to an argument regarding whether Section 1 was independently enforceable. And those authorities included Inchcup, Great Bay, Ferris, Society Docks, Thomas Baptiste, Lewis, Campbell Rodriguez, Newbold, and Nervas. So the usual, as I said, the usual suspects were before the court. So we say that this court now has the case of Great Bay. Inchcup chose to rely on Great Bay, and we have Ferguson. And we say this court, based on the principle in Young and Bristol Aeroplane Company, is bound by the prior Court of Appeal determination saying that Section 1 is not independently enforceable. Lord, if I can...
Just wait a minute. Could you, before we go to the next topic, I wonder whether you could assist me on something which may well not arise, but on which I'm not absolutely certain in my own mind whether it does or not. Could you go to the appellant's submission? And page 13, page 13 of those submissions at the very top, they set out the exceptions in Young and Bristol Aeroplane.
Yes.
To the rule that you must follow previous decisions. One is if there are two conflicting decisions. Secondly, it's bound to refuse to follow a decision which, although not expressly overruled, cannot, in its opinion, stand with a decision of the Supreme Court, and not bound by one of its decisions if the Supreme Court has decided the case on different grounds. Well, that's the point that we've just been looking at. And 3, the Court of Appeal is not bound to follow a decision of its own if given per incuriam. And then they consider the meaning of per incuriam, and what it quotes at paragraph 25 is a passage in Halsbury, which goes on to explain the per incuriam rule. And what it says is this: a decision is given per incuriam when the court has acted in ignorance of a previous decision of its own, or a court of coordinate jurisdiction which covered the case, in which case it must decide which case to follow, or when it has acted in ignorance of a Supreme Court decision, in which case it must follow that decision, or when the decision is given in ignorance of the terms of a statute, or when in rare and exceptional circumstances it is satisfied that the earlier decision involved a manifest slip or error, and there's no real prospect of a further appeal to the Supreme Court. A decision should not be treated as given per incuriam, however, simply because of a deficiency of parties, or because the court had not the benefit of the best argument. And as a general rule, this is the important passage, the only cases in which decisions could be held to be given per incuriam are those given in ignorance of some inconsistent statute or binding authority, even if a decision of the Court of Appeal has misinterpreted a previous decision of the Supreme Court. The Court of Appeal must follow its previous decision and leave the Supreme Court to rectify the mistake. Now, that appears to be, if correct, authority for the following proposition. The Supreme Court decides X. The Court of Appeal decides that what it meant in X is Y. There's then a subsequent case in front of the Court of Appeal, which on this hypothesis must decide the case on the basis on which the Court of Appeal interpreted the decision of the Supreme Court, rather than any interpretation by the subsequent Court of Appeal of what it thinks the Supreme Court meant. Is that right?
Effectively, it seems as if the Court of Appeal must be bound by its own precedent rules, and the Supreme Court is to be left to rectify the decision.
Yeah, that's what it says.
Yeah, yeah. Well, it seems as if that's the current position on the per incuriam rule, my lord. Yes.
So we appear to have the position, go back to page 13, item 2. It's bound to refuse to follow a decision of its own, which, although not expressly overruled, cannot stand with this must be subsequent decision of the Supreme Court, but it's bound to follow what the Court of Appeal regarded as what the Supreme Court had held in a decision that preceded the first sitting of the Court of Appeal.
Yeah. So effectively, then, the Court of Appeal would appear to be going against the Supreme Court until the Supreme Court changes its decision.
No, let's assume that the Court of Appeal number 1 decides that the Supreme Court meant X.
Yes.
And follows X. The same question comes before Court of Appeal number 2. It says that's daft. It's perfectly obvious when you think about it. that what the Supreme Court meant was not X, but Y. Since that what the Supreme Court meant, and we are bound by decisions of the Supreme Court, why should we regard ourselves as bound by what our predecessor took, the view our predecessor took, when the central question is what the Supreme Court meant?
That's correct. So, I mean, in each case, I mean, maybe I'm looking at this too simply, but in each case, wouldn't it be more appropriate for the Court of Appeal to be following the appropriate determination by the Supreme Court on the issue?
Precisely.
Regardless.
Precisely, but that's the exact opposite of the proposition set out in Halsbury, paragraph 25 of the argument.
Well, yes, I would have to disagree with that because effectively the Court of Appeal would be ignoring a binding Supreme Court decision in order to follow what could be an incorrect prior Court of Appeal decision. So I don't agree with that proposition.
No,
for the
well,
reason
I
that
think
you
it
said.
doesn't arise for decision in this case, but there are so many cases in their sequence that I can't, at the moment that I speak, say whether it might. But okay, thank you very much. That helped.
Yeah, yes, that's the Halsbury reference. I think it's safer for us to stick with the tried and trusted Young and Bristol and the Attorney General and St. Christopher.
Well, the curious thing, if you look at Young and Bristol Aeroplane, one of the exceptions is if the decision of the Court of Appeal is inconsistent with the decision of the Supreme Court. But at one stage, it says inconsistent with the decision of the House of Lords. Then, at one passage, it says inconsistent with the decision of the House of Lords. In another passage, it says inconsistent with a subsequent decision of the House of Lords.
Lord, thankfully, I don't think I have to address that point any further.
No, you do not. It's just that I thank you for your assistance.
Thank you, my Lord. If I can now turn to what we call the direction issue.
Yes.
Section 13 direction issue. The way we would like to start that is by, first of all, turning to our skeleton submissions in relation to the rule of law argument. And you may recall that at the time we adjourned for the last hearing, I actually had just reached paragraph 18 of the rule of law skeleton argument. And that is where I propose, with the leave of the court, to start today on this direction issue. So, as framed, it appears that the contention is that the respondents could, based on section 7AA, give a direction that contravenes section 13(1) of the Constitution, the direction. And so, first of all, Lords, paragraph 18 of the rule of law skeleton argument, we refer to section 7AA of the amended Municipalities Act, combined 2015 and 2018. And my lords have seen this before, but for ease of having the point before you as we go through the submissions, we see 7AA1, the minister may give written directions to a corporation, whether of a general or of a specific character, if he considers it to be in the best interest of Bermuda for him to do so, and the corporation shall carry out those directions. Any act or thing required to be done or done by a corporation in pursuance of the directions under subsection 1A shall be deemed to be for municipal purposes, and B is a function of the corporation. And 7AA2, before the minister gives directions to a corporation under subsection 1, he shall consult the corporation with respect to the content and effect of the directions. So paragraph 19 of that skeleton, the rule of law skeleton, in relation to section 7AA, the appellant argument is set out in paragraph 111 of their Court of Appeal submissions as follows. The appellants contend that the provision in the 2018 Amendment Act fundamentally offends the rule of law in that it provides in relation to the minister's power to give the corporation mandatory and binding directions, that such directions shall be deemed to be for municipal purposes and a function of the corporation. And their contention is as follows. It is clearly a contravention of the rule of law for a body with inevitably limited powers themselves to possess the power to define the scope of these powers. And then, my Lord, you'll recall from their skeleton argument, they cite a number of ouster clause cases. We say as follows, neither in section 7AA or elsewhere in the Municipalities Act does the legislature purport to exclude or remove either expressly or impliedly the court's jurisdiction over the scope and exercise of the power of the minister to make directions. This is critical as it makes the present case different from all the cases cited by the appellant in relation to the rule of law argument. It is clear that the court remains the ultimate arbiter in the sense of interpretation and application of 7AA. At best, the appellant's argument is that the power to give directions in 7AA is so wide that it allows the minister to define the scope of the power. This argument is misconceived for a number of reasons. First, the criticisms leveled at section 7AA are all remedied by exercise of statutory interpretation principles. There are presumptions and principles that operate that limit the power of the minister to provide and give directions to the appellant. The first case, Lord, is a case ex parte Pearson, which would have been provided with the rule of law skeleton argument, and it's a judgment of Lord Brown Wilkinson. Taking the indication from Madam Justice Gloucester that the reference for the page is either 574 in the body of the case, the foot of the page, or page 23 at the bottom right-hand corner.
Thank you very much.
So, as I said, this is a judgment of Lord Brown Wilkinson. On page 23 or 574, there's a reference to a paragraph. It's the penultimate paragraph. It begins, I consider first. I consider first. Page 23, penultimate paragraph, or 574. I consider first whether there is any principle of construction. Not sure whether everybody has found it yet. Some of what I'm about to submit is in the skeleton argument, some is not, which is why I've gone to the case on this occasion. But it reads, I consider first whether there is any principle of construction which requires the court in certain cases to construe general words contained in the statute as being impliedly limited. In my judgment, there is such a principle. It is well established that Parliament does not legislate in a vacuum. Statutes are drafted on the basis that the ordinary rules and principles of the common law will apply to express statutory provisions. And then in the next paragraph, where wide powers of decision-making are conferred by statute, it is presumed that Parliament implicitly requires the decision to be made in accordance with the rules of natural justice. And then there's a reference to Benyon. However widely the power is expressed in the statute, it does not authorize that power to be exercised otherwise than in accordance with fair procedures. This presumption was the basis on which this House held in ex parte duty that in fixing the tariff, those subject to mandatory life sentence, the Home Secretary had to inform the prisoner of the gist of the judge's advice and give him an opportunity to make representations. Those requirements were not expressed in the statutory words, but were presumed to be imported into them. Again, in the case of Honey, this House had to consider whether a power conferred by Section 47 of the Prison Act in absolute and general terms to make prison rules for the regulation and management of prisons authorized the making of rules which impeded a prisoner's right of access to the courts. It was held that the statutory words did not authorize such a rule. Lord Wilberforce, with whom the 3 other members of the committee agreed, said, in my opinion, there is nothing in the Prison Act that confers power to make regulations which would deny or interfere with the right of the respondent as a prisoner to have unimpeded access to the court. Section 47, which has already been quoted, is a section concerned with the regulation and management of prisons, and in my opinion, is quite insufficient to authorize hindrance or interference with so basic a right. The regulations themselves must be interpreted accordingly, otherwise they would be ultra vires. And then if I can ask you to go 1, 2, 3, 4 paragraphs on from where I just finished, there is a paragraph commencing from these authorities. I think the following proposition is established. From these authorities, I think the following proposition is established. A power conferred by Parliament in general terms is not to be taken to authorize the doing of acts by the donee of the power which adversely affect the legal rights of the citizen or the basic principles on which the law of the United Kingdom is based, unless the statute conferring the power makes it clear that was such of the intention of Parliament. So we rely expressly on that paragraph.
Just before we go further, I've been listening to what you say, but I've been trying to find ex parte person on the cloud. Despite my best efforts, it doesn't seem to be there. Where we sent it separately and it wasn't on the cloud.
But my lord, I'm not sure how you received your items, but if you received the rule of law argument, you'd have received it together with
I see.
Hartley Pearson.
Well, okay, it must have been sent in an email with the various authorities, and the authorities haven't been put on the cloud, unhelpfully. It's okay. I'll find it in the end.
Well, my lord, what I can say is this: the next quote that I am about to read, which is on page 7. Well, Lord, if I can ask you to look at page 7 of the skeleton argument I filed today.
Yes.
The next quote I'm about to read actually is at the top of page 7. The quote that I just read is at paragraph 23 of the skeleton argument.
I read that. I've got that. Sorry, but you're about to read something from page 7 of the skeleton. Which paragraph?
So it's paragraph 22, ex Pearson, that runs over the page onto paragraph into paragraph. It's 22 at the top of page 7, but it's numbered 22 on the previous page.
I don't follow this. My page 7, paragraph 22 reads, the control and management point was argued at first instance.
So
mine.
my lord, are you I may have confused you. Are you in the rule of law skeleton argument?
You said that you were referring to the skeleton you filed today.
Yeah, my lord, I apologize. I confused you. I meant the rule of law skeleton argument.
Right.
Yeah, that's what I've been looking at.
Yes. So
where are we on that one?
paragraph 22.
Yeah.
That should refer to ex parte Pearson.
Yes, it does.
Yeah. And so, my lord, you're saying that you cannot find the case of Pearson. And so I'm saying that the paragraph I just completed reading is in paragraph 23.
Yeah.
The paragraph I'm about to come to, I was going to read from the case, but I can read it from the skeleton argument, because I'm reading a paragraph that is on page 32 of the case, and I can read it here. Now, just by way of introduction, Lord Brown Wilkinson refers to this as a quote which he adopts from Sir Rupert Cross on modern statutory interpretation that he endorses in this case. Statutes often go into considerable detail, but even so, allowance must be made for the fact that they are not enacted in a vacuum. A great deal inevitably remains unsaid. Legislators and drafters assume that the courts will continue to act in accordance with well-recognized rules. Long-standing principles of constitutional and administrative law are likewise taken for granted or assumed by the courts to have been taken for granted by Parliament. Examples are the principles that discretionary powers conferred in apparently absolute terms must be exercised reasonably, and that administrative tribunals and other such bodies must act in accordance with the principles of natural justice. One function of the word presumption in the context of statutory interpretation is to state the result of the legislative reliance, real or assumed, or firmly established legal principles. There is a presumption that statutory powers must be exercised reasonably. These presumptions apply, although there is no question of linguistic ambiguity in the statutory wording under construction, and they may be described as presumptions of general application. These presumptions of general application not only supplement the text, they also operate at a higher level of expression of fundamental principles governing both civil liberties and the relations between Parliament, the executive, and the courts. They operate here as constitutional principles which are not easily displaced by statutory text. So that is the first reason we say that the suggestion of the direction that could be exercised in relation to 7AA with respect to section 13 is to be seen in the context that that power has to be exercised constitutionally and in light of the principles that determine that the statute must be exercised in conformity with the provisions of the statute as a whole. The second point we make in paragraph 24 of the rule of law skeleton argument is that the statutes are subject to the normal, well, primary legislation wouldn't be, but the minister's direction would be subject to the normal judicial review principles, which ironically, the appellants relied upon through the case of Jamaicans for Justice, which would not apply to primary legislation, but would apply to the minister's direction. So in the event that the direction was unreasonable, unlawful, illegal, or irrational, indeed unfair, that would be a challenge that could legitimately be made to any direction made under section 7AA. Thirdly, we say, and importantly, the minister is only able to give a direction to the corporation that is consistent with the powers within the statute. Section 7AA, based on normal statutory rules of interpretation, does not confer upon the minister a power to give the appellant more powers than it has under the combined amended Municipalities Acts. So as such, the minister clearly cannot direct the appellant to do an act or thing that the appellant is not already empowered to do under the Act. There are two express limits, paragraph 26. There are two express limits to the minister's power in section 7AA. The first limit is that the direction must be in the best interests of Bermuda. And that is important because within the context of the next limit, which is the consultation limit, that informs the nature of the direction that is given and the consultation that could be directed and inquired upon by the appellants with respect to that direction. It is important to note that the reference to the direction and its content and effect subject to consultation is not referred to at all in the appellant's Court of Appeal submissions, even though the very principles of consultation relied upon by the appellant at first instance, subsequently abandoned, apply, we say, to the minister's power under Section 7AA. And importantly, it should be noted that there is no limit on the appellant's right to challenge the consultation exercise in the Supreme Court or indeed on appeal. Lord, can I ask the court to turn to tab 67 of the bundle?
Yes.
Tab 67 of the bundle is a case called Matthew. Members of this court, I'm sure, have dealt with many consultation cases, but the principles are helpfully set out in this case. Can I ask the court to turn to paragraph 22? So this is the nature of the constraint that is placed upon the minister giving a direction in the context of the challenge. It would be in respect of section 13. So 22, in relation to each of the three decisions, Mr. Matthew relies upon a legitimate expectation of PTAs to be consulted, which he submits arose at common law. The decision maker may also be under a statutory duty to consult, which is what we have here, although that's not in the present case. In each case, the decision maker must act fairly. The requirements of fairness will be context specific and linked to the purpose of the consultation. In the case of a statutory duty, that context will include the terms of the statute. And that's an important point we make there. So the consultation in this case would not only have to be seen in the context of the constitutional requirements as to how to exercise the direction, but also with respect to the terms of the statute. Lord Wilson and Baroness Hale and Lord Clark referred to in the case of R versus Trafford. And then if I can ask you to turn to paragraph 23, there are four core components to fair consultation. They were first articulated by Stephen Sedley, as he then was, and accepted by Hodgson in the Gunning case. They were endorsed by the Court of Appeal of England and Wales in Coughlin and in the UK Supreme Court in the case of Mosley, which is the case referred to in paragraph 22. They are as followed: is it common ground whether or not a consultation of interested parties and the public is a legal requirement? If it is embarked upon, it must be carried out properly. To be proper, consultation must be undertaken at a time when proposals are still at a formative stage. It must include sufficient reasons for particular proposals to allow those consulted to give intelligent consideration and an intelligent response. Adequate time must be given for this purpose, and 4, the product of the consultation must be conscientiously taken into account when the ultimate decision is taken. And importantly, there has been a gloss that is relevant in this case over the page in paragraph 24. Lord Wilson identified 3 further points which emerge from the authorities. 1, the degree of specificity with which the decision maker conducts a consultation may be influenced by the identity of those consulted. The more expert the consultees, it may be the less need for specificity. And then 2, the demands of fairness are likely to be higher where the decision maker contemplates depriving someone of an existing benefit or advantage than when the claimant is simply an applicant for a future benefit. And 3, sometimes, particularly but not only when the subject of the consultation is limited to the decision maker's preferred option, fairness may require consultation about, or at least reference to, other options, even when these options have been discarded. So of those 3 points, I would say 2 could be added to the 4 principles in gunning with respect to concerns that the appellant may have in this case. 2, if an existing benefit is going to be removed, then the obligation of fairness is higher. And if there are preferred options that are discarded, there may be circumstances where it could be argued that the appellant is entitled to know what those preferred options are during the consultation exercise. So, well, we say that the combination of the obligation for the direction to be in the best interests of Bermuda and the statutory consultation exercise that must take place are 2 curtailments on the minister's powers, which are added to the principles of statutory interpretation that we have already submitted to the court. They would all apply with respect to how the minister would carry out the direction. Paragraph 27, there are numerous examples, we say, of widely drafted statutory powers conferred on ministers that have been subject to challenge on the basis of interpreting the scope or application of such a power, or whether or not there have been common law breaches in the exercise of that power. We submit that the power in section 7AA is no different. And we ask the court to turn to the case of Sharif versus the Minister of Home Affairs for the court's assistance. That is a case that would have been provided to the court together with the rule of law skeleton argument.
Yes, no, I follow that.
Yes.
My problem is I can't find those authorities on the cloud. I've got the rule of law skeleton, but only in hard copy.
Lady, what I can say is this. The court has the reference and hopefully the court clerk can assist you and at some point you can find it. But the passages I want to refer to are in the skeleton argument.
Yeah.
So in this,
Mr. Duncan, if you have the reference, could you give it to me now so that I can get it?
yes, it's 2015 Bermuda Law Reports 78.
Can anybody identify the email with which these documents were sent? A to Mr. Coelho and B by him to us, if they were.
November 10th.
I think the problem maybe we got these we got the skeleton in hard copy, but I haven't got the cases.
No, I think we received the skeleton by email.
Oh, did we? Okay.
Well, that's certainly the printing on my version is my print.
Right.
That's my recollection too.
My lords, I'm advised that the email was sent on Wednesday, the 10th of November at 8:45 a.m. And so that might help in your search.
Yes, it was sent to us on Wednesday the 10th. Now I found it.
I don't quite know why everything can't just be uploaded on the cloud. It's so much easier if everything's in one place.
Well, except what was sent then. Oh, yes, I see. Yes, it did include person.
So could one of my colleagues please tell me Wednesday the 10th from Mr. Coelho?
Yes.
11:57.
Thank you. And those are not on the cloud, is that right?
No, they're not.
Well, no, they are, but
What?
there was some difficulty in downloading them, which is why I sent the email.
Well, so they're not effectively on the cloud.
Correct.
Correct.
Well, could they put on the cloud? Otherwise, I have to remember when I'm doing my post-hearing reading where on earth these things are.
Yeah.
I mean, are they on the cloud? Are they
They're on the cloud in a folder that's marked further submissions by Duncan QC.
And are they in a form that we can access?
I'm able to access them. I'll
Okay.
cautiously say yes.
but those aren't the same cases.
No, they're not.
I mean, I can access what is attached to the further submissions by Duncan QC on the cloud. And those cases do not include the Antigua and Barbuda
No, they don't.
Constitution or Mr. Sharifi against the Minister of Home Affairs, or et cetera, or Pearson.
Right.
So if they could be put on the cloud, I would be grateful, because it's impossible for me to work from odd emails. And if
Yes.
Mr.
Mr. Duncan, for my part, I don't have, the only email that I received today at 8:52 was the emails that my lady is referring to.
No, I'm referring to the documents, the authorities attached to your email, Mr. Coelho, of the 10th of November.
That's correct, my lady. So what I'm saying is that the email sent to me from Mr. Duncan has the cases that you're able to open up in the cloud.
Yes, but I want to have them on the cloud, because I don't want to have to go back to my emails in a week's time or whenever, when I'm doing my post-hearing reading. And I don't want to have to print them out, because that's killing trees unnecessarily.
Yes.
So I'm making a request, please, that somebody should load them up onto the cloud. Is that possible?
I have no issue with that.
Thank
I
you very
think
much.
what I'm trying to say is that the email that Mr. Duncan sent to the court this morning have the cases that are in that folder I just referred the court to. Marked
Yeah, but that's true, but irrelevant, because we're not. The current problem is not about those cases. What
Well, I
happens?
don't have anything further.
Yeah. Right. Let's proceed.
Lord, the skeleton argument provides the reference for the case. I'm at paragraph 28 of the rule of law skeleton argument, and my lady Justice Gloucester will be able to reference the case from there. I'm actually not going to say any more than what is in the skeleton argument. This case was an immigration case. It was about whether or not the minister can deem somebody resident in Bermuda. The particular power and its breadth are referred to in paragraph 19.3 of the Immigration and Protection Act 1956. That's referred to in section 28 of paragraph 28 of the skeleton argument. It reads as follows: right of persons with Bermuda connection to Bermudian status. One, a person may apply to the minister under this section for the grant of Bermuda status if, and then B, he has been ordinarily resident in Bermuda for a period of at least 10 years preceding his application. 3, in relation to subsection 1, and this is the potentially offending section, A, where any question arises as to a person's ordinary residence in Bermuda, that question shall be decided by the minister. So that seems to give the minister unqualified, broad discretionary powers to make a decision as to whether or not a person's residence would qualify them for the grant of Bermuda status. Section 19.3a clearly has a wide ambit, seemingly unfettered, and the minister has a similar kind of power to that is being criticized in section 7AA of the Municipalities Act. In the context of this section 19.3a power, Kewali, Chief Justice as he then was, sided with approval pages 4 and 5 in the case of Sharif. One crucial issue of a legal character falls to be determined in this review, the court's consideration of the meaning of the words ordinarily resident, notwithstanding the minister's power under section 19.3a of the Act to determine the issue of whether an applicant has been ordinarily resident. The meaning to be attributed to those words is a question of law. In other words, whether on a proper consideration of the applicant's case, ordinary residence has been made out is a matter for the minister on consideration of the facts. However, the minister must decide that issue on proper legal principles. I should make one distinction here. The court is not being asked to consider the minister's discretion in determining whether any periods of absence from Bermuda for education purposes should be counted as periods of ordinary residence pursuant to section 19.3b of the Act. This is a matter for the minister and the policy by which he is guided. It is not the court's place to launch any incursions into his territory unless it can be shown that the minister has overreached his discretion. In this case, no such argument has been made. Suffice it to say, therefore, that notwithstanding the apparent wide ambit of the minister's discretion, the discretion is not unfettered and is itself subject to review by the court if it is exercised unreasonably or contrary to the spirit or letter of the Act or by offending any other legal principle. So we say that there is Bermuda legislative authority that ministers have similar to the 7AA authority under question in this case, and the courts with similarly wide discretionary powers have said, yes, they are wide, but the minister has to exercise them lawfully, has to exercise them reasonably, has to exercise them for a statutory purpose. The minister cannot breach the rules of natural justice, nor can he breach the rules set out and the provisions in the Constitution. We say, paragraph 30 of the rule of law scale argument, that the proper time to make this challenge is when the minister purports to give a direction under 7AA. At that stage, the appellants could determine whether or not it is unlawful, arbitrary, or demands something of the appellant that it is not able to do under the legislation. The appellant obviously would have notice of any such direction. We've gone through the rules on consultation. There would be a long period of consultation. When I say long, all of the requirements in gunning would have to be met in addition to the gloss put on those requirements by Lord Wilson in the case of Mosley. The court could then interpret the section 7AA direction and the legality of the minister's direction. We say, not surprisingly, that had the appellant taken the view that the power of itself was a breach of the rule of law, you would have thought it would have been challenged in 2018 when the Amendment Act came into force, at the very least before the learned Chief Justice, when the learned Chief Justice made a ruling on this matter. So, my Lord, I'm going to come back to the remedy sought at another time, but for now, I want to go back to the skeleton argument filed today and return to paragraph 14, which continues with our argument on the direction issue, the section 13 direction issue under 7AA of the Act. So, Lords, in support of the arguments we have made and the points made in ex parte Pearson, we also rely on the presumption of constitutionality. That is found in the case of Timberland. Again, understanding the position the court is in, the case of Timberland was provided today with the skeleton argument. But if the court or members of the panel cannot access the case, the relevant sections, I'm going to be referring to Timberland in more than one context, but the relevant sections for this portion of the argument are found in the skeleton argument. But if you have the case, it is paragraphs 29.
Well, we can see where it's set out, Mr. Duncan.
Yes, I'm obliged. So, reading the Timberland case, so far as the presumption of constitutionality is concerned, the Court of Appeal said that it had two components. The first was the principle that the court should, if possible, interpret a statute so that it does not conflict with any constitutional limitations. See Observer Publications and Matthew. The second component which the Court of Appeal identified was the constitutionality of a parliamentary enactment is presumed unless it is shown to be unconstitutional, is presumed unless it is shown to be unconstitutional. Sorry, that's the constitutionality is presumed to be the case unless it is shown to be unconstitutional. Paragraph 30. The board has no doubt that the first component is an important and valid principle of statutory interpretation, and indeed it is included in the Constitution. Article 65, as Lord Cook said in Observer Publications, paragraph 49, legislation should, if possible, be read down so as to comply with constitutional requirements. And as Lady Hale said more recently in interpreting statutory provisions, the board should presume that Parliament intended to legislate for a purpose which is consistent with the fundamental rights and not in violation of them. Greater circumspection is required when it comes to the second component. The board would accept that, save perhaps in extreme circumstances, a statute should be presumed to be constitutional unless it is shown to be otherwise, that insofar as it is helpful to speak of a burden in such circumstances, the burden is on the party alleging that a statute is unconstitutional and that any court should be circumspect before deciding that a statute is unconstitutional. Our submission is that paragraph 15, section 7A cannot be presumed to countenance a breach of the Constitution. The position in law is in fact the opposite. As a matter of statutory interpretation, there is a presumption that 7AA does not permit the minister to breach the Constitution. If the appellant in this case merely seeks a declaration that the minister can only exercise his power in section 7A in accordance with the Constitution, that is already clear as a matter of law and is in any event conceded by the respondents. But the problem lies in the fact that the appellants seek to determine the unlawfulness of the 7AA power with respect to potential breaches of section 13(1). Our submission is that in the absence of an actual or proposed breach, the point has been made by the respondent that an actual or potential breach is required for that kind of analysis. And the reason for that is that if the court assumes a breach of section 31, it deprives the respondent from relying on the defenses contained in sections 13(1) to A to D of the Constitution. So we say the exercise that the appellants are asking the court to do is depriving the respondents of the constitutional guarantee of demonstrating that whatever alleged breach of Section 13 is taking place is in fact defensible.
Could we pause a moment? Because I confess that I have slightly got lost as to what is in fact being asserted. You said a moment at the beginning of these submissions that it was suggested by the appellants that the government could give a direction which was unconstitutional, contrary to the Constitution. For myself, I hadn't picked up that that was what the appellants were saying, not least because I have some difficulty in working out what exactly it is that they're saying. But if you go to your rule of law, your original skeleton submissions in relation to the rule of law argument, you set out in paragraph 19 the appellant's arguments as set out in their submissions. And what is submitted is that the Act fundamentally offends the rule of law in that it provides in relation to the minister's power to give the corporation mandatory and binding directions, that such directions shall be deemed to be for municipal purposes and a function of the corporation. It is clearly a contravention of the rule of law for a body with inevitably limited powers themselves to possess the power to define the scope of those powers. Now, I expressed some difficulty in understanding what that meant when the argument began, and it was accepted that it wasn't particularly well drafted. But I did not understand it to mean that Section 7AA, 7AA1A, which provides that anything done in pursuance of direction shall be deemed to be for municipal purposes, meant that the government could do that which was unconstitutional, could disobey the Constitution. Didn't understand that to be being said at all. And if it was being said, it would seem to be manifestly erroneous because, well, a number of simple reasons, one of which is that the Constitution takes precedence over any statute. What I had understood to be being said was that it enabled the minister to do practically anything, provided it was something that he wanted to do. That didn't seem to me to be, and the matter that I raised with Sir Geoffrey is that if one looks at it in terms of varies, 7AA1A appears to provide that anything which the minister requires the corporation to do shall be deemed to be for municipal purposes and the function of the Constitution. So I have a little difficulty in understanding, if one is considering varies, why, if the minister requires the corporation to do something, that doesn't fall within the varies of the corporation, given that the varies of the corporation, as determined by the Amendment Act, are to do that which the minister tells it to do. The more pertinent application, I would have thought, of the more pertinent problem would be something like the following. Assume that the minister decides that Bermuda should adopt a more outgoing approach to the world and should be more charitable to the outside world, and says that a portion of the corporation's monies should be devoted to helping Afghan refugees. That would appear, that's got nothing to do with the constitutional rights. That would appear, taking 7AA, 1AA at face value, to be an order from the minister, and the thing required to be done under it, pay some of your money to Afghan refugees, is deemed to be for municipal purposes. Now, the question that would then arise is whether or not the effect of 7AA 1A is that the deeming should be conclusive. Spending money on Afghan refugees is very worthy, but it's plainly not, in ordinary language, a municipal purpose. So the question that would then arise is whether or not the deeming was conclusive, to which I would have thought there was a very strong argument that at best it could only be a provisional deeming. But it was that sort of activity, there may be other examples, that I took to be the basis of the complaint that a body with limited powers can't possess the power to limit the scope of those powers, define the scope of those powers. What I think was meant to be said is that it can't be right that the minister, by the use of a power which, when exercised, provides that it's to be a municipal function, that can't mean that the minister can conclusively determine that it is a municipal function if it plainly isn't. But so it may be that I've got muddled, but I hadn't understood that what we were dealing with was the suggestion that 7AA 1A could be used to do something that was unconstitutional, but that it could be used to do something which previously would not have been regarded as municipal or a function of the corporation, to turn it into one. You see my difficulty?
Well, this is where it's become very difficult to follow the argument they've made, because at one point, I mean, the reason we've called it the Section 13 direction issue is because it was related, the way a number of points have been made. It's not just going to be one point I say that's been made. I recall at one point, and Sir Geoffrey will correct me if I'm wrong, that he said that it was, unconstitutional. There were some rather florid words used about the exercise of this power. And then on another occasion, for want of a better way of putting it, hypothetical was put out there that this would allow the corporation to be the subject of a direction to take away all of its property. And so that's why it's framed this way. So, my lord, I can address your concern as well, but I just want the court to know that my understanding was as put in the skeleton argument, but I can address it. I can address the concern that you have expressed as well. And so maybe I've got it wrong, but because the point is not that clearly put in paragraph 111, I have been trying to identify what it is and have struggled, candidly struggled to try and work out what point they are making and how I should best address it. So, my lord, as far as the point you've made is concerned, in the event that there was a direction to transfer monies to what may objectively seem to be a worthy cause for the benefit of Afghan refugees, our submission is that the normal principles of statutory interpretation and the protections within the interpretation of the minister's power would apply. First of all, it would have to be determined whether or not it is a purpose within the Act. The reality is the minister cannot direct the corporation to carry out a function and deem it to be a function that is outside the terms of the Act. And the canons of statutory interpretation I've directed you to suggest that that is how that power is to be determined. There are rules with relation to consultation, and it's got to be in the best interests of Bermuda. It's difficult to see how objectively, with other competing economic demands in the community and in the corporation, that could be in the best interest, economic interest of Bermuda. But the reality is that there would be a consultation process that would take place where that could be challenged. And in the event that the direction continued into a determination, then the appellant would have the right to challenge that direction in the Supreme Court. But that does not mean that the minister's power should be curtailed now on a hypothetical as to how that direction may be exercised. It may never be exercised. There is no reason for this court, based on the principles of statutory interpretation that I've gone through, to make a preemptive decision and say, we take the view that if a direction is made in a manner X, it would be unlawful. And we're going to craft declarations to say what directions are lawful and what directions are unlawful. And that's the part of the rule of law skeleton argument dealing with the remedy that I didn't deal with, but I will come back to and deal with that, because one has to think about the practicalities of how the court would actually draft a direction to deal with that issue, my lord. So, my lord, I do apologise to the court and indeed to...
No, there's nothing to apologise for.
My lord, I wonder if I could, with your permission, make a very short intervention. I have prepared a very short summary of position on this issue. Excuse me. And I'd like, if with your permission, to hand it up, as it were, to the court now, because I think it may assist. What you have just said, my lord, is precisely what is troubling us about this provision. In short, it confers authority to amend the foundation of the power that is conferred without any parliamentary oversight. And it thus seeks to shield from jurisdictional challenge, because it is a deemed power and it has no limits. It seeks to shield from jurisdictional challenge both the exercise of the minister's overbroad, we would say, discretionary power, and the acts or thing done in response to his direction by the corporation. Lord, I explain this more carefully in the note, which I would ask to be able to submit.
Well, it would be quite helpful to have it. It would be helpful to have had it a little earlier.
The note has been uploaded to the cloud. It's under further submissions of Joe QC.
Lord, I haven't seen that.
We'll join the club.
Sorry, my lord?
Join the club.
Yes.
It was very much drafted with a view to replying to the submissions of last week.
Yeah.
Mr. Duncan, if you have your emails up, it was on an email sent at what would be 10:16 a.m. Bermuda time.
Oh, good. Thank you. I think. Mr. Myers.
What I prefer to do, if possible, rather than just derail
Yes.
submissions, what I prefer to do is I'll make a couple of points on this now, and then during a break I'll get a hard copy, and if I need to say anything further, I'll do it at a later time.
Okay.
Because I just think it's going to derail.
Yes, all right.
And I don't know how much time the court has.
Right. Keep going.
Lord, my preliminary view with respect to, and I just wrote this down hurriedly, and you know, I don't need my learned friends to correct me. If I have it wrong, then I'll have it correctly when I see it in the break. But what I have is the power confers authority to amend the power without parliamentary oversight and shields the minister through that power from jurisdictional challenge. And the minister's power, anyway, I'm not sure I got the rest of it, but in any event, I understand the core of it, which is that it's a self-regulating, unconstrained power that the minister has without subject to control. That is, but my lord, the reality is it is subject to control. It's subject to control based upon the statutory principles of interpretation as to how that power is to be used. The fact, and this is, my lord, where I think we are swimming into unconstitutional grounds, because if this power is, as my learned friend suggests, it would be unconstitutional, because the suggestion is that it's a power that's exercised without parliamentary oversight. That would be out with the writ of the Constitution. So to some extent, I am comforted by the fact that I did in fact make those submissions, because it seems as if it's swimming back into the territory of unconstitutionality. And the reality is that that is not how that power is to be interpreted. It is to be interpreted as read in conformity with the Constitution and to be exercised in conformity with the Constitution. And the reality is that the way that my learned friends are putting their case, they are saying, read section 7.1 AA as if there are no constraints, whether it be by the Constitution or by the common law, with respect to how the power is being exercised. You, court, they are saying, make a peremptory decision now, regardless of the fact that even on their view, 95 to 99% of the decisions may not be subject to challenge. But let's say that one decision is subject to challenge. And even that has got to be subject to either section 13.1 A to D if it's a direction in property, or subject to consultation. But even that one decision, they are saying, draft the declaration or read down the whole power to deal with that one particular instance. My lord, it's just not the way I respectfully submit that this court should construe a minister's powers. But I will come to make further submission on it once I've read the actual provision. So, my lord,
Well, just before we get into the next aspect of the exercise, if we look at your original rule of law submissions,
Lord, yes,
you say at paragraph 25, it's important to note that the minister's power is to give directions. The appellant is a body corporate with limited powers conferred under the Municipalities Act. On one construction, 7AA does not confer the minister a power to give the appellant more powers than it has under the Act, but given the minister a power to give directions in accordance with those powers. The trouble with that is that 7AA says the that anything done in pursuance of the minister's direction should be deemed to be for municipal purposes and is a function of the corporation. And that is a statutory provision. So what it provides is that if the minister says do this, it will be a function under the Municipalities Amendment Act, whichever one it is, to do what the minister says.
Yeah, but it's, let's just have a look.
You say the minister wouldn't be able to direct the appellant to do any act or thing that the appellant is not already empowered to do under the Municipalities Act. What can have been the function of the amendment to the Municipalities Act to say that what the minister requires to be done should be deemed to be for municipal purposes and a function of the corporation?
Lord, I think that that was designed to ensure that the minister can give explicit directions. And that was designed with concerns with respect to a number of the issues that arose for corporation to consider, like the Mexican infrastructure finance case, where there was the unlawful guarantee that had been entered into. And in those circumstances, there were things like whether or not the minister could direct that the corporation can, in fact, guarantee for the purpose of construction. But it wasn't designed to give the minister powers to do anything that was totally out with the statutory context.
Wait a minute. Let's take the guarantee. The Court of Appeal and ultimately the Privy Council by a majority have held that the guarantee given in that case was out with the powers of the corporation.
Well, yes.
That prior to the amendment law was the law. It was not within the power of the corporation to give a guarantee. Under this new provision, 7AA1A, is it open to the minister to say, you shall give the guarantee? And if he gives it, will the guarantee fall within the powers of the corporation?
Lord, my view is that this particular provision only allows the minister to give powers, to give directions within the powers that are contained in the Act.
So your answer to that, Mr. Duncan, is that the minister would not be so able?
Yeah, he can only give powers that are within, yes, he would not be so able. That's the way that the statutory interpretation clearly directs the minister's powers in this case.
So, although it's an amendment to the Act and an amendment of the functions of the corporation, in order to determine whether it's something that the minister can ordain, you have to ask whether it was in the powers of the corporation and one of its functions prior to the time when he gave his direction.
That's correct, yes.
The point of the provision then. Other than to give the lawyers something to argue about. I mean, what is the utility of the provision if that is the interpretation?
Well, my lord, all I can say is that's the way the law construes that particular provision.
I'm sorry, my lord, perhaps I could be of a little bit of assistance. I just happen to know the history of this really well. This amendment was actually in response to the judgment of my Lord Bell in the Mexico infrastructure finance case, where my Lord Bell said that the corporation was limited to municipal purposes. And an example was given of an airport or something. And I think my Lord Bell said, well, no, you couldn't do an airport, you couldn't do an Olympic stadium, things like that, because those wouldn't be municipal purposes. Although they might benefit Bermuda as a whole, they would not be for the purposes of the municipality. This amendment was intended to get round that so as to enable the minister to make it possible for the corporation to do those things. And you will note that it's very carefully stated that the minister's powers are constrained by the best interest of, I'm sorry?
I'm sorry, everything broke up.
Oh, I'm sorry about that. Well, I'm saying that the minister's powers are different from the corporation's powers. The minister's powers are constrained by the best interests of Bermuda as a whole, whereas the corporation's powers are constrained by the best interests of the municipality. And that difficulty having arisen in the case law, this was passed in response to it so as to enable the minister to give directions which would bring the corporation out of those strictures. It's in the explanatory note, which I can find. I just.
Well, that would help. That would be helpful if you could find the explanatory note.
I think it actually mentions the case.
It would be helpful if you could find it
Judge.
for us in due course.
Yes, I will do, my lord.
So what I'm being instructed by by Miss Sadler-Best, who's with me, is that the purpose of the power is that if, for example, there is a power to, let's say, lease or sell, the minister would use the power to do is to lease or sell to a particular person. So it's not extending the powers, it's a direction with respect to his powers, extending them just to say it may be used for a particular purpose, but it's not extending the powers of themselves. That's the understanding as to how the 7AA direction is to be used. It cannot extend the minister's powers to
point of it.
So it's the same question as I asked before. What's the point of it? It doesn't extend the powers.
Well, no, but what it does do is if there is a challenge to say that you cannot direct, corporation says you cannot direct me to, let's say, for example, give to X or give to Y, because all you can do is direct that it be sold. The minister can direct the manner in which it can be sold, which may not be within the powers that are currently in the municipal acts. So it's more about the process and, let's say, the identity of the individual or circumstances surrounding the existing powers that are not explicitly set out within the powers themselves, but is not designed to extend the powers as they are. And my lord, I don't think that the construction can read it any other way, because if the minister was here to say, I'm going to deem you to say that you can sell land to X to build an airport, which is not within their powers, one, it would be immediately challenged, and two, it would be challenged on the grounds that it's not within any remit of the powers that currently exist.
That's not right.
That's our submission.
Yes. The trouble is you keep on referring to the powers that currently exist, whereas this act is a new provision. Saying it's limited to the powers that currently exist begs the question as to whether by the amendment it confers some new ones.
Well, to the extent that I've expressed, I think what you have is a situation where, you know, the appellants are positing, as they did before, unconstitutional reaches.
No, we're not.
As a,
I think you need one person speaking at a time.
I'm not sure if anybody else is making a submission now.
There was an interjection by Mr. Myers. You should continue, Mr. Duncan.
Obliged. So, my lords, I'm being instructed that that's how the power is to be interpreted. It's not to be interpreted as giving the minister powers, wide, unrestrained powers, as suggested by the respondents. I think the court has to understand, and I say this with respect, that whatever the words say, they have to be interpreted in conformity with the normal rules of statutory interpretation and the normal rules of construction that I have gone through.
Well, the easiest way of dealing with is to say it may be deemed to be a municipal purpose, but if the order was you must use your funds to build an airport, that's plainly not a municipal purpose, and the deeming isn't conclusive. I mean, that's the way to get around that problem.
Right.
Right. Where should we go from here?
Lord, I was
Where had we got to?
I'm trying to recall. I think
Oh, sorry, I took you out of.
no, that's fine. I believe I had finished the rule of law skeleton argument, and
And I mean, just before you finish on the rule of law, I mean, what is said is that the provisions, or this provision, is contrary to the rule of law in section 1C or whatever it is of the Constitution. But if that is right, it's also contrary to the common law, is it not? So we don't need the section 1 of the Constitution. Oh dear. Lost Mr. Duncan. Mr. Quille, can we find out what's happened to Mr. Duncan?
I'm just waiting for him to come back online so I can admit him.
But no, thank you. Thank you.
My Lord President, if I may, whilst we wait for my learned friend,
Yes.
what I have found in relation to the 2018 excuse me, Amendment Act
Yes.
is the ministerial statement which sets out what the objects of the act are from the government's perspective.
Where will I find that?
That is in the record, beginning at page 292.
Yes.
Yes, And if one goes to
Sorry, which page again, Mr. Myers?
the
292?
292, yes, of the record. And if one, this is the big red numbers on the bottom right-hand corner, because there's other numbering, but that's the number.
Is it?
Right. And then if you look at 295, bottom of 295, second bullet, and it shuts on, then just read the last sentence and turn over the page. This would have allowed, for example, the minister to directly intervene in issues such as the recently announced closure of the docks, a problem that has developed over time, allow the minister to direct the corporations to undertake projects that will provide economic benefit to the whole of the island, such as the Hamilton waterfront of the St. George's Marina. We have learned that the 2016 Court of Appeal judgment in the matter of Mexico Infrastructure Finance ruled that the development, the Palaville Hotel, could not be progressed because, quote, the development would be something which would clearly be for the benefit of the whole island, but does not relate to the functions of the local government of the city of Hamilton in particular, and was therefore ultra vires. So that is saying in terms that, and that actually is an extract from the judgment of my Lord Bell.
Oh, right.
Hello.
Yes, hello.
Yes.
Are you with us, Mr. Duncan?
I apologize. I'm on another device because there was internet problem.
Did you hear what Mr. Myers was just saying when you were?
I've not heard any of it. No.
I'm
Well,
so sorry.
No, well, that's not your fault. If you go to the index, the record of appeal,
Yes.
and go to page 292, there is a ministerial statement from the Minister of Home Affairs in relation to the Municipalities Amendment Act. You've got there.
Yes.
And if you go to page 295, at the very last bullet point, he says that the bill seeks to provide the following: allow for the minister to provide directions to the corporations if he considers that it's in the best interest of Bermuda, and ensure that the corporations give effect to any such directions. This would have allowed, for example, the minister to directly intervene in issues such as the recently announced closure of the docks. Next point, allow the minister to direct the corporations to undertake projects that will provide economic benefit to the whole of the island, such as the Hamilton waterfront or the St. George's Marina. We have learned that the 2016 Court of Appeal judgment in the matter of Mexico infrastructure ruled that the development of the Palaville Hotel could not be progressed, and because, and these are words taken from Justice Bell's judgment, the development would be something which would clearly be for the benefit of the whole island, but does not relate to the functions of the local government of the city of Hamilton in particular, and was therefore ultra vires. So the House was being told that the purpose of this provision was to ensure that there could be done now that which was ultra vires before.
Lord, yes.
Discuss.
That may be the reasoning that was given by an legally informed member of the House, but that doesn't change the way in which this court will interpret the statutory provisions based on the basic principles of statutory interpretation.
Right.
And further to the comments that you made before I got cut off with respect to the deeming and whether that deeming is lawful or unlawful, it could subsequently be challenged. But the reality is that we say, regardless of what the government may say or may want to do, the reality is it can only be interpreted in a way that is consistent with the law, and that is what the court is here to do.
Right.
So, Lord, I was I believe at paragraph 17 of the skeleton argument filed.
So which skeleton argument are we on now?
The skeleton argument filed today.
Yeah. Thank you.
Paragraph. I'm being told I was at 16. I think I just completed 16. And this is addressing the point that there are potentially arguments that could be made when there has been a potential breach, but and this is part of the problem, dealing with exactly what the assertion is being made by the appellants. But I suppose it could be equally opposite to the example that my lord gave with respect to donations to the Afghan refugees. We looked at it in the context of the complaint that was made during the course of the hearing, which was with respect to a direction to transfer property.
Yeah.
And all we're saying is that, to use the pleading analogy, don't leap before you get to the stile. We actually don't know what the nature of the direction will be, and what this appeal seeks to do is, with a broad sweep, say the minister cannot have such powers, when the reality is, based on the principles of interpretation I've mentioned already, the position should be that the minister exercises the powers and all of the protections are in place for consultation. There would be consultation. The power must be exercised for the best interests of Bermuda. And if that was not the case, there could be a challenge. And we say that one of the arguments, I have no doubt, one of the arguments that the appellants would make is that the particular direction is not either for a municipal purpose or in the best interests of Bermuda. And that would be raised, one, during the consultation exercise, and if the direction was still made and the decision approved, it would be made in court if they challenged such a direction.
But Mr. Duncan, I mean, isn't it unrealistic to think that a challenge could get as far as court, and you would have a newly constituted corporation which would operate under the direction of the minister, who would control such challenges? He's hardly likely to endorse a challenge against himself or the course he wants to pursue.
My lord, in the event that there was unlawful activity on the part of the minister, there could be a challenge by the mayor and the councillors. They would be able to challenge. The fact that he is acting unlawfully doesn't mean that he can't be subject to challenge, unless the court is saying that. But
the minister can direct the process, can't he?
He couldn't stop. He could not stop himself carrying out. He could not stop the corporation resisting an unlawful direction. I don't believe that's the case, no. If the minister, or let's posit an example, the minister gives a direction which appears to be unlawful, or let's say it is unlawful, the minister gives a direction. The corporation has the right to challenge without the approval of the minister. The minister doesn't have to approve a legal challenge. They could challenge.
That's not, I'm so sorry, that's not true. Everything that the corporation does has to be by resolution, and every resolution requires the approval of the minister. A resolution to start litigation will require the approval of the minister. Simple as that.
That's how I thought it would operate, Mr. Duncan.
That's completely true, my Lord Bell.
Well, Lord, is Mr. Myers here now with the approval of the minister?
Sorry?
Is Mr. Myers here now with the approval of the minister?
What does that mean, Mr. Duncan?
I don't know.
Well, remember now, Section 7AA came into force in 2018.
Yeah.
We're here now.
Yeah.
My Lord, we're here. My Lord Justice Bell, we're here now. So I don't know what. I don't know what. My Lord, can I make my points without Mr. I mean,
I'm so sorry. I'm so sorry.
Am I interacting with him or am I interacting with the court?
That is
It's not.
true. I'm very sorry. My apologies.
Lord Justice Bell, we are here now on an appeal subsequent to the enactment of the 2018 Act. This is exactly the point I'm making. I can't, let's see if I can see the whole court. Well, Lords, unfortunately, my camera seems to be just on Mr. Myers, so I'm trying to make sure I can see.
That
Well,
is
we-
unfortunate, Mr. Duncan.
We can see you, Mr. Duncan.
Right. So my Lord, now I can see. Obviously, I can only see the person who's speaking. So,
Mr. Duncan, I'm not deaf, but I'm having a bit of trouble hearing you because everybody else I can hear perfectly. But when you lean back from your microphone, it garbles it slightly. Thank you so much.
I apologize. So, Lord Justice Bell, the point I'm making is that albeit amended, but the legislation that is being attacked was enacted in 2018.
Right.
We are in court now. So obviously, the point that Lord Justice Bell has made is not correct. They are in court exactly as I said.
No, but I was looking forward, Mr. Duncan.
Right, but my Lord, I would have thought, my Lord, that they would have stopped if the point that the court has made is correct. We wouldn't be before the court now.
Well, just a moment. The new arrangements that the minister appoints the corporation effectively, or some council appointed by him appoints the corporation, that's in the reform bill, isn't it?
Right, but the resolution has to go before the minister for his approval.
Well, that's the present position. The present position is that under the 2015 Amendment Number 2 Act is that no resolution of the corporation is to have effect unless and until approved by the minister.
And I'm advised, my Lord, and we will get the authority, that there is a case in which Chief Justice Cabley said that despite the amendments, you cannot stop access to the court. The corporation cannot be stopped in its access to the court. And I think the case is going to be found. So we cannot stop access to the courts.
Well, it would be certainly helpful to have that case. I mean, I don't know whether a resolution was ever passed by the corporation that it should bring this litigation. If the resolution was never passed, I'm not quite sure why we're here. If it was passed, I assume it was approved by the minister, but I don't know.
It was not, my lord.
Was there a resolution?
There was, my lord. And the minister refused to approve it. And the minister also refused to approve a budget which included budgeting for this litigation, despite the decision that my learned friend is going to bring forward, which I agree does exist. But there we are. That's where we are right now. We are here in defiance of that refusal.
Right. So where we are at the moment is there was a resolution. The minister refused to approve it. There is a decision of Chief Justice Cabley that doesn't stop the corporation from proceeding. That's where we are at the moment. If the bill takes place and passes into law, that will presumably remain the position. But what is said is that the likelihood of the minister, or the corporation suing the minister, is slim, given that this is how it's put, the corporation will become his lackeys.
My Lord, the corporation will not become his lackeys. And the reason for that is because if you look at how the corporation is going to be selected, it's going to be democratically elected through the ballot box. The minister will be selected through the ballot box. The reality is that with the vicissitudes of elections, there will be some ministers that will support the current mayor and councillors, There are ministers that may support different mayor and councillors. That's not a matter that this court should.
Mr. Duncan, I really don't understand how you can put forward that argument when ministers are not going to vote against the government, are they?
Well, it depends on which government you're talking about.
No, if the minister wants to follow a particular course, just by the realities of cabinet unanimity, another minister is not going to cross his decision. It's not going to happen.
Well, my lord, one, I think that is not a decision that this court should be making, because it's
no, but I mean, you posited the possibility that the democratic process would operate in some way with ministers voting on the issue, and I'm just saying that.
Voting? No, I was not on voting on the issue. No, that isn't what
but that they would in some way. The minister is going to take such courses he deems appropriate, and that will be the end of it. There won't be any process involving other ministers. Maybe I misunderstood you.
Yeah, I think you did, my lord. If you look at the schedule, I was going to come to it under the freedom of speech argument, but the reality is that not only is the council made up of, I'm not going to use the word lackeys. The council is made up of people nominated by the government of the day. The government of the day is selected by the people of Bermuda. That is the democratic process. The people of Bermuda select the government of the day, whatever complexion it is. And,
right.
the government of the day selects the minister. That is the democratic process, unless this court is saying we're going to upturn the democratic process. That is a fair democratic process for the selection.
No one's disputing that.
Well, and then the combination of councillors is made up of those selected by the minister and those selected by members of the public. So 4 of the councillors.
No, it isn't. No, wait a moment. Under the Municipalities Reform Act, the municipal elections are abolished, and the members of the council comprise a mayor and 8 councillors. The mayor and 4 of the councillors are appointed by the minister, and the other 4 are appointed by the minister on the recommendation of the selection committee, whose members are themselves appointed by the minister.
Yeah, but my lord, the members of the public, as I understand it, have a right to, I'm looking at the course schedule now, appointment and tenure of office. If you look at Schedule 4 to the Reform Act 2019.
Yeah, where do I find that? So sorry, where do I find that?
My learned friends provided a bundle with the legislation.
Oh yes, they did. Yes.
And where is it in that?
It's tab 7.
But Schedule 4 in tab 7?
That's correct. Yes, page 5, section 2.
Yes. Well, I've got that.
So all I'm saying is that, I mean, either the court takes the view that a legislative body, such as a corporation, created under statute, has entrenched rights, or that as is the case with most municipalities created in other jurisdictions under legislation, as here, they have the right through the democratically elected governments to make rules and regulations for the conduct of that body. And all we say is that there is a democratic process through the election of the government of the day that can exercise statutory powers to determine the composition and decision-making of such a body as the Corporation of Hamilton.
But isn't that process just as my Lord President described it? 4 appointed by the minister, 4 appointed by the selection committee, which the minister controls.
Well, my Lord's using words like control. I mean, okay, my Lord, if those are the words you want to use, I'm going to use the word democratically elected through a process. I'm not going to use.
Well, I don't know
Well,
why.
no. It was control of the select. I quite follow that the minister and other members of parliament are elected, but once they're elected, there is no further democratic participation in the council, because its ministers, the members of the council, are appointed either by the mayor or by a selection committee, whose members are to be determined by the minister.
The selection committee, yes, the members are determined by the minister.
Yeah. So the expression
The minister controls the process.
Sorry, my Lord?
The minister controls the process.
My Lord, I'm not sure. I'm going to go back to my point. I'm not sure what the problem
You
is.
didn't like my use of the word control, and you referred to democratic principles, but the minister appoints the 4, and he appoints the selection committee, from whom the other 4 are appointed. I don't see why you have difficulty accepting that.
Well, I don't have difficulty accepting it, save for it provides an assumption about the fact that the minister will somehow thereafter stifle, or as my Lord said, his lackeys will
No, I didn't use either of those words. I simply said that the dealt with the appointment of the councillors.
I apologize, my Lord. I thought I heard somebody use the word lackey. If you didn't use
Yes,
it.
I did. I probably shouldn't have used it, but I meant it as a slang expression to indicate that in reality, the minister was likely to have the control of the corporation, and that in those circumstances, the idea that the corporation would sue the minister for acting beyond his powers was remote.
I think the correct word is poodle, isn't it? Rather than lackey.
All I can say, my Lord, is that my learned friend has conceded, and we can find the authority that says that the reality is there is no prohibition on access to the courts. So if the argument is being made that the corporation will no longer have a right to challenge in the courts, one, Justice Cabley has made sure that that's not the case, and 2, if the argument is being made that it won't be the case because, to use the pejorative term, either the lackeys or the poodle of the minister will be in place, Lord, either we're going to assume malintention on the part of the minister and those who he appoints. And if that's the way that...
We're not making that assumption, Mr. Duncan.
Well, my Lord, let me just posit the position. If the position is being posited that there will be malintention on the part of the minister and those he appoints, then it's difficult to argue against that. Because in any scenario, malintention can be imputed, and malintention will then lead to directions that this court may find disapproving.
Well, sorry, let's take a concrete example. Piet assumed that under the Reform Bill takes effect, and the minister says, as was indicated to the House when all this legislation was passed, one of the purposes was to enable the minister to give directions which would avoid the problem in Mexico infrastructure. And I propose to give directions that the corporation should construct an airport. The government's been entirely open about this. It's what was said in the House. The legislation has been passed. An airport is not a municipal purpose. So theoretically, one would expect that the corporation might wish to challenge the minister's use of his powers so as to force the corporation to create an airport. But in circumstances where the minister has appointed the members of the corporation or has appointed the committee which appoints the members of the corporation, although in the light of Justice Cowley's judgment, it would be perfectly possible for the corporation to seek judicial review of the government, the likelihood of it doing in those circumstances is remote.
Lord, I have a different view. My view is that if
You don't accept that, Mr. Duncan?
No, I don't, Lord. I think if you have law-abiding citizens who have been appointed to this corporation, they will act in accordance with the law. I do not countenance, and I say this quite strongly, that you will have people who are appointed who will be yes people and no people. I strongly reject, and I think people who would be appointed as councillors would equally firmly reject that. I think that is, if I may say so, an unfortunate characterization of people who would be appointed to do public service.
Well,
if they believe that there is an unlawful act that's going to take place, this court is going to have to divine and assume that those people will compromise the law because of who has appointed them. No, I do not accept that. I can say,
well, you use the word unlawful act. I mean, it would be perhaps better to take the example of an act beyond municipal powers, such as posited by my Lord President.
Or if it was beyond the powers, that body would not countenance it.
That assumes that the body takes the view that it's beyond the municipal powers.
Well, Lord, the reality
in relation to, yeah, sorry, go on. The reality is,
guys, I interrupted you, but
no, I interrupted you.
I'm going to make the same point. We have to assume that those appointed by the minister are not going to have the wherewithal to determine whether through themselves or otherwise, or they will kowtow to the minister and assume that everything that the minister says is lawful and they will not challenge. And I do not.
Mr. Duncan, I mean, with respect, that's simply not real world. And I'd rather take a more realistic example and take the example of the Mexico infrastructure case. Suppose that the minister thought it was very much in the interests of Bermuda to build a large hotel on the Parlaville car park. Are you seriously asking us to believe that the persons whom he has hand-selected for the position of councillor on the corporation, whether the 4 he appoints or the 4 appointed by the selection committee, are not going to go along with the wishes of the minister?
Lord, I've been involved in a case this year with a board that I will not name, where I was representing a party who refused to go along with a direction against the wishes of the minister. And I actually represented an individual in that circumstance. So, my Lord, I mean, when you say, am I seriously, I say this without disrespect. I am seriously asking the court to consider strongly before it makes a decision that members of the council body would not follow the law. and they're not going to just do what the minister says. I mean, I find it quite astounding that the court is suggesting that members of a body would just go along with what the minister directs because they've been appointed by him. That is not real world. That's not my experience.
Very well.
Right. Where have we got to?
Lord, I think we're at paragraph 18 of the
Yes.
skeleton filed today. I think we're at paragraph 18.
I think
So,
that's where we were.
yes. So we say, despite the protesting of Mr. Myers at the hearing on the 10th of November, the Section 13 direction issued in relation to potential deprivations of property was not addressed in the judgment of the learned Chief Justice below, nor is the learned Chief Justice criticized for not doing so. This is not surprising given the concession made by the appellant in paragraph 100 of the judgment. And again, my lord, before I read this concession, I know that the questions that have been directed to me today have concerned directions other than directions in relation to Section 13. But originally we thought that it was in relation to Section 13, and the concession that was made is as follows. Mr. Deal accepts that the Amendment Acts do not purport, and the proposed Reform Act would not purport to directly transfer either property or property rights to the government. So within the context of Section 13, and I'll come back to it, this is the concession that was made by the appellants in the court below.
Emphasis on the word directly, perhaps.
Not, my lord, maybe, but I'm not sure that's important when one considers Section 13.
Right.
When one considers Section 13 of the Constitution. And we'll come to that when we see what the Chief Justice said. It should also be noted that the appellant sought to have all of the Amendment Act and Reform Bill declared void, that should be void and of no effect, which is inconsistent with seeking a declaration based on Section 7AA alone. Because as we understand it now, this is an argument on 7AA. It's not an argument with respect to all of the acts. We're trying to follow the argument, but that's what we understand it to be. And that's how we understood the argument to be articulated in exchange between the appellant's counsel and the president. And indeed, when I interjected and asked Sir Geoffrey what argument was being made, it was in relation to 7AA, my understanding and recollection. Whether, my lord, on paragraph 19, whether it's a Section 13 direction or any other direction, we still maintain that the proper time for the challenge to be made is when the direction is taken. We now have a situation where looking at a Section 13 direction, I'll look at another direction outside of Section 13.
So you keep on referring to a Section 13 direction.
Sorry, taking a direct. Right. Sorry, it's a direction under 7AA for a taking under Section 13. I apologize. I was contracting the point. But we've now got to the situation where not only is there a suggestion that there should be a challenge to potential directions under 7AA, Not only have we got a situation where if it were a direction with respect to section 13, that would deprive the government of relying on the defences, we've now got a situation where it's being suggested that the legal challenges which the law affords them won't be taken by virtue of the powers the minister has to create the council and the councillors. These are all speculative assertions, my lord, and they should be rejected. We say, paragraph 20, as it stands, even under the Reform Act, the appellant is still a body corporate distinct from the government. There is a presumption that section 7A does not permit the minister to make a direction that is in contravention of section 13(1), or indeed any other law that is out with the powers of the minister under the Municipalities Act. To the extent the minister directs the compulsory taking of property or the compulsory acquisition of and right of interest in property, it has to fall within section 13A to D to be in conformity with the Constitution. It should also be noted that these principles apply whether or not the transfer of the appellant's property is a function or purpose of the appellant by legislation or deemed by section 7AA. So whether the minister acts in accordance with a direction under 7AA or any other power, he still has to comply with the law and the Constitution. Analyzing potential breach of the Constitution in these proceedings is premature. Such analysis assumes a breach of section 13(1) and indeed any other law, while depriving the respondents of the opportunity to rely on section 13A to D or any other defense, as they would be entitled to if such a taking or compulsory acquisition was actual or proposed. The presumption of constitutionality sufficiently addresses the concerns about the minister's section 7AA power in relation to the appellant's constitutional rights and indeed in relation to any other potential breaches. The defences could be relied upon. And as I've been told, and my friend has agreed, my learned friend has agreed, Chief Justice Kawley has said the provision does not deny access to the courts. Lord, I'm advised the case is in the bundle at tab 62. It's in the bundle. Tab 62.
Thank you.
Paragraph 43. Now, this is a case paragraphs 43 and 44, Lord, I can let you read those.
Yes.
Yes, so that we say deals with the point with respect to access to the courts. And then if I can ask the court to look at paragraph 22.
Well, so just pausing there for a moment. You say it's far too early to reach any decision as to what the minister might or might not do under the powers that he's got under the various acts.
Or will have under the Reform Act.
Well, he won't have any
Yeah.
new powers under the Reform Act, will he? Other than in relation to the composition of the council.
Right.
But just sort of thinking matters through, it is self-evident, is it not, that there are some things that the minister could do or purport to do under the powers that he now has to direct the corporation in effect to do anything. There are some things that the minister could do which would plainly breach the constitutional rights of the corporation. Assume, to take the most obvious example, the minister says to the corporation, you must transfer your land for nothing to somebody other than the corporation. That, and you're not going to get any money for it. That would plainly be a breach of Section 13, unless the minister could bring himself within some of the exceptions to Section 13.
That's correct, Lord, yes.
But whether or not, and if he did that and didn't come within the exceptions, either he had apparent power to do it, but what he did was a breach of the Constitution, in which case the Constitution would take precedence, or his apparent power must in fact be treated as limited, so as not to entitle him to do that which would be a breach of the Constitution. And it doesn't really matter which of those it is.
That's correct.
However, there are other cases, more borderline, and there may be a whole lot of stuff to debate about whether or not preventing the corporation from making a sale amounts to the minister acquiring, at any rate for a moment, for a time, an interest in property. And there are other less clear cases which you say may arise, but if they arise, will have to be determined on a case-by-case basis.
Well, yes, because failing that, what you're doing is you're divining ahead of time that the defences in Section 13A to D, 1A to D, don't apply, and or you're divining that in a certain circumstance, the government may not be prepared to pay compensation. You're divining a whole series of things.
Yeah.
It's just not possible to divine at this stage, unless you start the process by assuming that the government is going to act unlawfully and continue to act unlawfully, and that there will be no constraint by the court.
And you say that it's no doubt for those good reasons that the argument below doesn't appear to have addressed the issue of potential deprivations of property, as a result of which they were not addressed in the judgment of the Chief Justice, and appears only to have addressed the question as to whether or not the amendments that had been made to the Municipalities Act and the proposed municipal reform bill, if enacted, whether the combination of those would amount itself to something which fell within section 13 of the Constitution.
Yes, yes. I mean, it's effectively what we're about to come on to now, which
Yeah.
is the control issue.
Precisely.
And that control issue has as its backdrop the point that I made at paragraph 18 of the skeleton argument, which was the reference to the concession that was made below. So, Lord, the concession made below was that there was no evidence of a taking or an acquisition. And so, as a consequence, the argument centered on control. And we're about to come on to that. My Lord Justice Bell said that there may be emphasis on the word directly, and I will address that within the context of what this constitutional provision allows. So, my Lord, a few points to make. Firstly, if you have the Constitution to hand, I don't know whether that was one of the documents that was provided to you.
Not in fact.
Ah, okay. Well, you don't necessarily need it, my Lord. I can just make, I don't want to put the court to any trouble.
Well, which section are you referring to?
I'm going to be referring for this one.
I'm so sorry. Yes, okay.
1C and 13. 1C, we make this submission. I mean, I'll read it so that the court has it, and I'm sure we.
Sorry, can you repeat it? Because I had to get my copy of the Constitution.
My lady, yes.
Which section are you looking at?
I'm looking at section 1C and section 13.
Yes.
Well, we say that there is force in the submission that all section 1C does is describe a right contained in section 13. Section 1C says that no person shall be deprived of property without compensation. If we look at section 13, section 13 is entitled Protection from Deprivation of Property. It is our submission that in addition to the arguments that section 1 as a whole is not independently enforceable, the extent to which section 1C can assist in interpreting section 13 is very little, if any. And I'll come on to this point shortly when we deal with the case of Campbell Rodriguez. So if I can now turn to paragraph 23 of our submissions. Lord, I confess to a submission that may not have assisted the court as much as I could have with respect to the issue of deprivation of property under section 13. I think some of the submission got caught up in nomenclature, and some of the submission got caught up in trying to provide a chronology of the cases, which was not helpful. The position we say is this, paragraph 23. First of all, the reasoning in Panton in the Privy Council is binding, we submit, on this court. Now, the appellant relies on the case of Lawrence. However, that was a Court of Appeal authority, I believe in the Eastern Caribbean. Panton is a Privy Council authority, as I say, binding on this court. Not only is Panton inconsistent with Lawrence, maybe the other way around, but the Privy Council in Panton expressly distinguished Lawrence at paragraph 22. The reason this all becomes important, my Lord, is because Lawrence is the case about control. So having jettisoned reliance on a taking or an acquisition. They stake their case on control, and Lawrence is the case on control. And this is what the Privy Council said in relation to Lawrence in the case of Panton. At paragraph 22, Lord Clyde says the appellant sought to found upon Lawrence, but that case concerned the removal from office of one who was not only a shareholder, but a managing director who drew a percentage of the profits from the business. In that case, a taking of property could be identified. In the present case, no one has been dismissed, nothing has been taken. The shareholders remained holding their shares. The statutory provisions were, as the Court of Appeal recognized, of a regulatory, not a confiscatory nature, and no obligation for compensation arises. So let us look, my Lord, if we can, at the case of Panton, which is at tab 48 of the bundle. Now, if I can ask the court to look at the head note, the facts on page 132. Page 132. And the factual context is important, not only for my submission before this court, but for how the Chief Justice arrived at his decision. The appellants were shareholders in 3 financial institutions. Following investigations into the activities of one of the institutions, the Minister of Finance and Planning assumed temporary management of the 3 institutions under Section 25 of the Financial Institutions Act, 1992. The appellants commenced proceedings claiming that the provisions of the 1992 Act and consequently actions of the minister were unconstitutional since they amounted to the compulsory acquisition of property without compensation, a right protected by Section 18 of the Constitution. Over the page to 134, the third finding, the other findings are not relevant, they deal with the issue of bias. To establish their claim under Section 22 of the Constitution, the appellants had to show that the action of the minister under Section 25 of the Financial Institution Act constituted a taking of their property. However, what the minister did was to take over control of the company. The appellants remained shareholders, and none of their property, including their shares, had been taken away. Equally, no one had been dismissed, and thus no one had property taken in the sense they were removed from office. Ultimately, the statutory provisions were regulatory rather than confiscatory, and therefore no obligation to compensate arose. Now, if I can ask the court to turn to page 141. Paragraph 18 at the foot of the page.
Paragraph what, sorry?
18 at the foot of the page. 18. So having dealt with the issue of bias in the first sentence, they go on to say, this relates to the constitutionality of the Financial Institutions Act. The particular section of the Constitution which is relied upon is Section 18. That section reads as follows. And then you see, no property of any description shall be taken possession, and no interest in or any right over property of any description shall be compulsorily acquired except by or under the provisions of a law that A, and then there are the defenses there set out. And then, Lord, if I can ask you to turn over the page to page 22, sorry, paragraph 22, page 143. And in the context of what we read, they say the point here is a short one and admits of an immediate answer. The appellants have to show that the statutory provision constitutes a taking of their property. But what the Act empowers and what the minister did was a taking over of the control of the company. The appellants were and remained shareholders of the company. Their shares would doubtless qualify as property, but their shares were not taken away. They no longer had the control of the company, which was inherent in the shareholding which they possessed. But the assumption of temporary management by the minister did not involve the taking of any property of the appellants. The regulation of the company was in the hands of the minister. That the regulation of the company was in the hands of the minister did not mean the appellants had any of their property taken away from them. There's a reference to the Belfast case that we've seen before, but in this context, I'll just read it again. Viscount Simon said that in ordinary English language, the issue of taking would surely deny that any one of those rights, which in the aggregate constituted ownership of property, could itself and by itself aptly be called property and come to the instant case. He would deny that the right to use property in a particular way was itself property, and that the restriction or denial of the right by local authority was a taking away or taking over of property. And then the next paragraph is the one I've just read. So, Lord, in this case, we note that Panton was approved in Campbell Rodriguez. So if I can ask you to turn to tab.
Just before we get to Campbell Rodriguez, can you help me on something?
Yes.
The decision at 22 of Panton is in effect that there was here no taking of property without compensation, and reliance is placed on Viscount Simmons, who says that anybody would surely deny that any one of those rights, which in the aggregate constituted ownership, could itself be called property. And to come to the instant case, he would deny that the right to use property in a particular way was itself property, and that the restriction or denial of that right was a taking away, or a taking over of property. If, however, so that's all based on taking, but if you go back to paragraph 18, they set out the provisions of the Constitution, which are identical to the Bermudian Constitution. And going to H, that section reads as follows: no property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired. So the Constitution doesn't actually refer to a taking of property. It refers to the taking of possession and the acquisition of an interest in or right over property.
Right. Mm. So is your point that the
my point is that if, as the judge said, we ask ourselves, was there a taking of property? That may not be the right question.
In this case, or you're saying in the case of Panton, or in the case of
well, in both.
In both. Well, I mean, I suppose what we're guided by is section 13 of the Constitution. And in section 13 of the Constitution, it says no property of any description shall be compulsorily taken possession of, and no interest in or right over property of any description shall be compulsorily acquired.
Yeah. That's exactly the section I referred to a moment ago.
And so the reality is that in this case, there's no evidence of a compulsory taking, and there's no evidence of a compulsory acquisition, either of an interest or right over property.
When you say in this case, in which case do you mean? Do you mean the case before us?
The one before this court, yes.
Yeah.
The one before the court. And we've had a concession that was made by the appellants in the terms in paragraph 100 of the judgment.
What, just remind me of that again.
Lord,
You had
I'm gonna
it.
go- I'm going to go through the judgment extensively.
No, we
but
had it a moment ago.
Yeah, you can find it, paragraph
Yes.
18 of the
Yes.
submission.
The proposed act, amendment acts do not purport, and the proposed reform act would not purport to directly transfer either property or property rights to the government.
Lord, the case put below, which we accept we have to face squarely, is one of control.
Yes.
The argument is that the effect of the combined pieces of legislation is that it takes away control from.
But if I, being entitled so to do, say to you, you can't do anything with your property, either indefinitely or for a period, it might not be difficult to conclude that I was thereby acquiring an interest in property, namely the interest to use the property as I wanted to.
Well, it depends what one means by you can't do anything with it. That certainly isn't this case.
No, I know it's not this case. Of course, one must look at the facts of this case.
Yeah.
But in order to determine the true construction of the terms of this constitution, it is necessary and perhaps helpful to decide whether it would apply in an extreme case in which government says you can't do anything with your property, which is the ultimate form of control.
My Lord, it still depends on what you can't do anything with your property means, because if that means you still are in possession of your property, the issue then would be to what extent the government have exercised rights over your property. And I suppose the closest analogy we have to that would be an expression of a loss of enjoyment of rights over your property. And currently, our constitution does not grant a right to enjoyment of rights of property, and I'll come to that shortly. In the cases, one of the cases that my learned friends rely upon is Pampanet. That case is not helpful to this court because it relates to the enjoyment of rights over property, which are distinguished in Campbell Rodriguez by Lord Carswell as different and distinct in their constitutional nature from the rights of taking and acquiring. And although a lot of this sounds highly technical, that's the way that the courts have interpreted these provisions, and I can come to them. Because there is a clear distinction between the enjoyment of rights within a constitution and the taking and acquisition of rights within a differently worded constitution. So, my Lord, trying to assist with the ambit of the constitution, I think I was going to go to Campbell Rodriguez, which is at tab 14.
Just a second, yes. Well, just before we do that, if we go back to Viscount Simons, the passage at paragraph 22 of Panton,
Yes.
he says that somebody would surely deny that any one of those rights which in the aggregate constituted ownership could itself and by itself aptly be called property, And to come to the instant case, he would deny that the right to use property in a particular way was itself property. Now, I had rather taken him to be proceeding on the basis that the right to use property was one of those rights which in the aggregate, in other words, when taken with others, constituted ownership of property, but that the right to use property was a right in property.
Lord, no. I mean, when I made my submissions at the start of my response, I went through a number of propositions, and one of them was taken from this case, that the right to use property is not a right that is protected under Section 13 of the Constitution.
Well, you may have did that, but but where did you get that from this case?
I got it from this quote.
Well, what I was suggesting is that the quote might mean something completely the opposite. The quote distinguishes between individual rights, which in the aggregate constitute ownership of property on the one hand, and property on the other. The right to use property isn't property, but that begs the question as to whether it's one of those rights which in the aggregate constitute ownership of property, whether it's a right in property.
When he says would surely deny that any one of those rights which in the aggregate constituted ownership of property could itself by itself be called property, that's dealing with a bundle of rights. So the rights don't constitute property.
No.
And to come to the case, he would deny the right to use property in a particular way was itself property.
Yeah.
And that the restriction or denial of that right by local authority was a taking. So the bundle of rights in aggregate is not property for the purpose of the Act. The right
well, the whole bundle is.
Well, yeah, that any one of those rights, which in aggregate constitute ownership of itself, and by itself that would be called property, right? And then the right to use property in a particular way is not property sanctioned.
No.
And the restriction or denial of that right by a local authority was not a taking. So that's where I got the...
Yeah, that's all fine. I don't have any difficulty with any of that. But the difficulty, the thing I'm on about is that given that the constitutional right is not limited to taking and extends to the acquisition of a right in property, could an acquisition of the right to use property or to prevent somebody else from using it constitute a right in property covered by the Constitution? It might be convenient if we took a break now. I think we've had rather a long period. Perhaps we can leave that in the air for the moment.
Well, yes.
Perhaps, Mr. President, we could just discuss timing.
Yes, precisely. How are we getting on? We've been asked rather a lot of questions, which is not your fault, but how much longer do you think you have?
Lord, I have got to go through the, I've got to finish this point, and then I've got to deal with what now is turning out to be a bit more lengthy than I thought. Freedom of expression argument, which the court has asked me to deal within a slightly different way to that, which I had considered. So what is it now? It's 12. What time are we concluding, Lord?
Well, no later than about 7:30 our time.
Right. Lord, so today is the last day for this hearing.
Well, whilst we've been on air, as it were, there have been some developments in relation to our case for tomorrow. I think we'd better come back on timing after the break, because those developments may affect how we are disposed. But how much, I know these things are very difficult to estimate, but how much longer do you think you need?
Okay. I could try and crack on. I've got this. I could try and crack on and try and get it done within an hour and a half. But I just don't know. I mean, I anticipate I'm going to get quite a lot of questions on the freedom of expression point.
The Lord Mayor says,
Yes.
May I desist if I say that in respect of section 9, the expression point, I don't find that it is necessary for us to pursue motive. And so we will rely much more on the effect of the disbanding of elections rather than any kind of motive.
Okay.
And if that may shorten.
Well, that would help. But it would help if you,
evidence.
yes, I follow that. Yeah, but that would help if you could tell me how long you think you need.
It's very hour and a half, perhaps.
Right. Okay. You sent a supplemental note, which I have printed out. But the note that I printed out didn't seem to me to correspond with what you said it would contain. And the note I have got has 11 submissions, which are basically as to whether or not various different cases are ratio or obiter.
Oh, yes, this is a note that that Mr. Myers has developed, which is a revision of our paragraph 20 of our initial submissions.
Yeah, I'm sure. Okay, let it be so. But where is the note to which you were referring?
The one on the
That
rule
note
of law.
was also sent. I'm sorry, my lord, that note was emailed to Mr. Coelho as well at the same time as this one. I thought he had said that he'd put it on the site.
He has put it on the cloud.
Has he?
Well, there are some additional submissions from Sir Geoffrey on the cloud. I don't know whether they're the ones.
No, there are some additional submissions on the cloud.
There should be two.
Oh, yes, I see. Yes, I found it now. Okay, thank you very much. Well, we will resume in 45 minutes' time. Thank you.
Thank you, my lord.
Thank you.
Thank you, my lord.
Are we going to the breakout room, Sir Christopher?
Yes, we are.
Sorry, let me get out of here.
No, you can stay, Mr. Myers. Just turn your
Oh.
camera off and.
I'm about to turn everything off. I'm sorry.
you to use the word resembles.
Just waiting for the president to come through the vortex. Okay, Mr. Duncan,
Yes.
I'm ready for you.
Um, yes.
Well, yes, my lord. I think that we were at paragraph 24. Actually, no, we were at paragraph 23. I think I finished at 23. I was about to move into 24, and we were discussing the case of Panton.
Yes.
Yes. Before we do that, I just want to make one point that in relation to the rule of law, section 13 direction issue. I just want to reiterate the submission that if the concern the court has is that through the Schedule 4 appointment of the mayor and the councillors, that there will effectively be a rubber stamp of the minister's decision. I would submit that the court should not impute a compromise of the independence of the members of that body without more. I mean, the reality is that, for want of a better example, judges, for example, in the Supreme Court get nominated and selected. Nobody assumes that there is a compromise of their independence as a consequence of that. And I would just caution the court not to arrive at that conclusion lightly, that there will just be a rubber stamp of the body that is appointed. I think that's, if I may say so, a rather sizable leap that the court shouldn't take.
Accept that, Mr. Duncan. I don't think your analogy is a very good one.
Sorry, my lord?
The court has the good fortune to be irremovable.
Sorry?
The Supreme Court has the good fortune to be irremovable,
Yes, my lord.
possibly by the affirmative resolution of both houses.
But my lord, as I said before, irrespective of whether they are removable or not, it seems as if the concern that the court has, and to that extent, I'm glad I came back to it, is that somehow an individual hitherto of independence and good reputation appointed to a body by a particular person or party loses that independence, whether they can be removed or not removed, I would ask this court not to assume that citizens of this country would behave in that way. I think that is a leap.
Right.
And it's a leap that a lot of people would find quite objectionable, to think that they are being appointed just because they are going to follow lockstep, whatever it is they're told. And I think that's an important point.
Yeah.
What about the point of depriving the ratepayers and residents of Hamilton of their ability to vote their own mayor and corporation?
Is that the freedom of expression point, lady?
Yeah.
Which I'll come on to. Yeah,
We're
but
coming to that.
I was just
Okay.
about to finish the
Okay.
control point, which is on paragraph 24. So, my lord, we were dealing with the issue of control, and I think I was going to come on to Campbell Rodriguez. Now, as I said, I was going to come on to Campbell Rodriguez. I think you said you wanted me to go back to Panton. Campbell Rodriguez is at tab 14. Lord, that is a case involving the Jamaican Constitution. If I can ask you to turn to page 531. You can see that there is a reference to section 13 of the Constitution, whereas every person, and it relates to life, liberty, security of the person and the enjoyment of property. And Lord Cars will come on to explain that point. And then with respect to...
Where is this at 531?
Sorry, 531 at the top of the page, there's a reference to section 13, which is the equivalent of our section 1.
Yeah.
Yes.
So 531 section 13 is the equivalent to our
Yes. Right.
section 1, and it's the reference though is to enjoyment of property. And then, my lord, you can see that at paragraph E, sections 14 to 17 deal respectively with protection of the right to life, protection from arbitrary arrest or detention, protection of freedom of movement, and protection from inhumane treatment. Section 18 then makes provision in respect of compulsory acquisition of property, the material subsection for the process of this appeal, for the purpose of this appeal. And then you see it follows our section, no property of any description shall be compulsorily taken of, and no interest in or right over property of any description shall be compulsorily acquired. And then you've got the exceptions. So we've already seen that in paragraph 7 of the judgment, it says it was contended on behalf of the appellants that section 13 had independent effect in the conferment of constitutional rights, which their counsel, Mr. James, described as a declaratory force. Alternatively, as a minimum, he submitted it was to be given effect as to aid in the construction of section 18. The Constitutional Court and the Court of Appeal rejected the argument that section 13 had the function of an instrument for providing redress. They relied in particular on the wording of section 25.1. We don't need to go into that any further, but suffice to say that my Lord President asked me a question on the prior occasion, which was to what extent you can use section 1 as an aid to interpret section 13. And the court goes on to say at paragraph 13, they answer that question. The appellants argued in the alternative that for the purpose of section 13, that the provisions of section 13 could give some assistance in the interpretation of the subsequent provisions of chapter 3. That may in principle be so, since a statute has to be read as a whole if there is any ambiguity in the meaning of any of those provisions in the language of section 13, and it throws any light on the intention of the legislature as to the meaning. For the reasons which they will give, however, their lordships do not consider that there is any ambiguity in the terms of section 18 on which the wording of section 13 would throw any light. They do not propose, therefore, to express an opinion on whether the words enjoyment of property in section 13 are intended to connote anything more than the individual's right not to be deprived of his or her property. So the analysis there for us is this, my lord. We have in section 1 a reference, a board reference to deprivation of property. We have the heading in our section 13 that refers to deprivation of property. And then we have the provisions of section 13.1 that say that no person shall be deprived of his property, either by taking or acquisition of a right or interest. It is our submission that section 1C of the Bermuda Constitution provides no greater aid to interpret section 13 of the Constitution. The reason for that is because it's just using the same words in section 1C as are found in the title to section 13. And we say, based upon Campbell Rodriguez, that that submission is a fortiori of greater force in this case, because in Campbell Rodriguez, the section 1 equivalent of their constitution in section 13 contained the words enjoyment of property, which are not found in our section 1 equivalent. And despite that fact, Lord Carswell suggests that that throws no additional light on the interpretation of words in section 18, the equivalent of our section 13. So for that reason, we say that in addition to the arguments we have made with respect to the lack of independent enforceability of section 1 in its entirety, and the fact that this is a Privy Council case dealing with loosely deprivation of property, we are constrained in our interpretation of section 13 by section 13 itself. There is no ambiguity that has been raised in relation to section 13 that would require some form of interpretation of section 13 by section 1. Now, to deal with one of the questions I think that was raised by the Lord Justice Bell, that was a question with respect to whether or not the concession that was made in paragraph 100 of the appellant's skeleton argument with respect to property was only in relation to direct or indirect.
Don't believe I put it that way. I just commented that no doubt the appellants would place emphasis on the word directly. I say no more than that.
I apologize, my lord. I thought there was more to it than that. But in paragraph 15 of this same case, we have some illumination on that point. It may be observed first, there may be a taking which is not a direct physical appropriation of property or an ouster of possession, nor does it appear necessary to show there has been a transfer or change of ownership or possession from one to another or body. See Belfast Corporation. Some limitation of the apparent breadth of legislative provisions prohibiting the taking of property without compensation must be implied. It is necessary to take care not to be over-analytical in examining the separate components of a phrase which requires construction, and the issue is to be determined by considering the application of the phrase as a whole. It may be of assistance, however, to consider first the meaning in the context of interests in or rights over property, and then turn to that of acquisition or its synonym taking. Mr. James, for the appellant, submitted that the word property should be given a wide or purposive construction, argued that the right to obtain access to one's property without economic burden constituted a property right. Examination of this concept, however, reveals the existence of a number of difficulties. And in this case, it was because a number of members of the public would have use of the road. Every member of the public is entitled to passage over the road. All of these people will be economically affected. And then over the page, paragraph 17, it has been generally recognized both in a long series of cases in the United States and in many other jurisdictions that taking is not limited to direct appropriation, but may encompass regulation of the use of land which adversely affects the owner to a sufficiently serious degree. It is equally well recognized that states may pass legislation regulating the use of land in the public interest which does not carry the right to compensation as a taking of property, even though it may have significant adverse economic effects of the property owners. The American cases are constantly cited in this context, and examples may be found from other jurisdictions. It may be necessary to use such authorities with a degree of caution, bearing in mind the differences in wording of the applicable constitutional provisions. And there's a reference to the Belfast case. And there's a reference to a Pennsylvania case where the restriction was deemed to be in the public interest. And then in paragraph 18, the cases on regulation provide analogies which give a measure of assistance in approaching the issues in the present.
Wait a minute, we're just pausing there.
Yes.
By citation from Pennsylvania Co., every restriction upon the use of property imposed in the exercise of the police power deprives the owner of some right, therefore, theretofore enjoyed, and is in that sense an abridgment by the state of rights in property without making compensation. So that would appear to recognize that if you tell somebody that he can't use property, that is that you are depriving him of his right. And it might be said, acquiring the right to do so.
Yes, but then the issue is a matter of degree, as you see in the.
No, but that I follow.
Yes.
But going back to the point that I was making before, there's a difference between taking property and acquiring a right in property. And
yes.
Depriving somebody of the right to use property could be said to be an acquisition of the right of use.
But normally, my lord, that often through government intervention is by regulation. And
Quite.
Yes, and then the issue becomes whether the regulation goes too far and whether it deprives the person of the actual intrinsic rights within the property to use that property. So it's a matter of degree then.
A matter of degree, yeah.
Yes.
I agree with that. It's a matter of degree, but one can't say that there are no circumstances in which preventing somebody from using property could go beyond regulatory control.
Lord, that's correct. And they discussed that in paragraph 18. If you see, in paragraph 18, they discuss the cases on regulation.
Yeah.
They provide analogies. And this is what they say with respect to that in paragraph A. They establish clearly that there are limits to the concept of taking property and that some types of state action which could linguistically be so regarded are not to be regarded as justiciable. It is well established that measures adopted for the regulation of activity in the public interest, such as planning control or the protection of public health, will not constitute the taking of property, notwithstanding the fact they may have an adverse economic effect on the owners of certain properties. And this is sometimes, my Lord, where I think the confusion arises, because even though it is a taking in the grammatical sense of the word, it may not be described as a taking in the legal sense under the Constitution. And that's where sometimes the wording and how you describe the activity can get confused. And then it says, there's a reference to Panton, again, which Lord Carswell supports, is the board held that the assumption under statutory powers by the Minister of Finance of the temporary management of certain companies whose affairs were under investigation did not constitute a taking of the appellant's property. It is the respondent's case that the replacement of an existing highway by an improved road on which a toll is charged is governed by the same principle. Their lordships regard the analogy as persuasive. The project involved the replacement of an inadequate public road and bridge by an improved road and a new bridge designed to inure for the benefit of the public in general by speeding the flow of traffic and relieving congestion. It was to be financed not by taxpayers as a whole, but by charging tolls to be paid by those using the road. Their lordships consider the words of Viscount Simons in the Belfast case were apt when he asked rhetorically whether anyone using the English language would say this meant that the authority had taken property. The appellates cannot, in their lordship's opinion, establish the construction of the new road and the charging of a toll for its use constituted a taking or acquisition of any proprietary right capable of coming within section 18. So, the Lords, we rely
Did the complainants, they had a right to use the road?
That's correct.
So charging them to do so is said not to have been the acquisition of any proprietary right. But it would, I hear what they see what they say, but if I'm entitled to go from A to B, and somebody says, it says in future, you can only go from A to B if you make a payment, doesn't that somebody acquire, in effect, a proprietary right?
Well, they
to
said
prevent me from going on the road without paying.
They said that that didn't amount to a proprietary right or a taking within the terms of section 18 of the Constitution.
Yeah, well, what's not wholly clear to me is whether that's because it couldn't be said to be the acquisition of a proprietary right at all, or whether it wasn't the acquisition of a proprietary right capable of coming within section 18 because it was in effect a beneficent regulatory measure.
Well, they use words, Lord, I'm not sure whether it's going to be helpful, but in paragraph 18, they go back to not constitute a taking. They do go back to the words within section 18.
Yeah, they do.
And they say that the analogy is persuasive. And the Lord, we say that the analysis in this case, together with the case of Panton, are binding on this court because they are Privy Council cases dealing with the application of section 13, which is the very issue we're dealing with here in relation to control. So we say that we commend the reasoning in those cases on the court when they come to assess whether or not there has been the assumption of control.
I think what it amounts to is that a restriction on people's entitlement to use a property doesn't fall within the purview of acquiring a right in property within the meaning of the relevant section. even though linguistically it could be regarded as that or something similar, because there's a distinction between things that are done for regulatory purposes and things which go well beyond that and are done for some different purpose.
Lord, yes, that's the distinction that they draw between a regulatory or a confiscatory taking. Yes,
That makes it even more confusing. You can have that's a good way of putting it. You would have a regulatory or a confiscatory taking, and although they're both takings, it's only the confiscatory one that comes within the section. Yeah.
Yeah. Lord,
Right.
our second submission of paragraph 25, rejecting the submissions with respect to control, is that the measures in the present case are nowhere near as intrusive, and by present I mean as asserted by the appellants here, are nowhere near as intrusive as the actual taking over of the management in Panton, which we say is binding on this court. The present case is not one in which the management of the corporation has been taken over by the respondents or the government. The management will still lie with the appellant. The requirement that approval be sought in relation to resolutions is not of itself management, but oversight. It's our submission that this is a case of oversight, not with respect one of control.
Yes.
So further, a decision whether or not to give approval is also subject to the common law principles set out in the rule of law. I'm not going to go back to those, but my Lord, if you can put a footnote there that the approvals would be subject to the statutory rules of statutory interpretation, paragraph 24 of the rule of law submission, the cases on irrationality, unreasonableness, illegality, and unfairness, and the constraints on the interpretation of powers within the section. Paragraph 27, in light of the above, the Court of Appeal, we say, should consider the approach by the Privy Council in Campbell-Rodriguez, where Lord Carswell posed a relevant question as follows. Their lordships consider that the words of Viscount Simons in Belfast Corporation were apt when he asked rhetorically whether anyone using the English language would say this meant that the authority had taken properties. It is submitted that the respondents clearly have not taken the appellant's property within the meaning of section 13. Thirdly, the appellants rely on the case of Papinet. Papinet is at tab 49 of the bundle. Lord, you will see that first of all, this is on page 2, under held, you will just see that there's a reference to section 4A of the Constitution, 3 lines down under held. Regulations were substantial and prima facie infringed their right under section 4A of the Constitution not to be deprived of the enjoyment of their property. And that enjoyment and the other important words, that therefore the government had to show that the applicants had been deprived of their right to enjoy the property by due process of law. And this case involved one of representations that were made with respect to the transfer of a taxi license, following which the appellants had to not only pay, but apply to their competitors to use the same rights that they had before. Lord, if I can ask you to look at page 7, paragraph 8. This is important. The Constitution of Trinidad and Tobago provides, so far as material, it is hereby recognized and declared that in Trinidad and Tobago, there have existed and shall continue to exist without discrimination by reason of race, color, religion, or sex, the following fundamental human rights and freedoms, namely, A, the right of the individual to life, liberty, and security of the person, and enjoyment of property, and the right not to be deprived thereof, except by due process of law. Stopping there, Lord, we need go no further. The case of Papanek is distinguishable on a number of grounds. Firstly, the right was being enforced under a constitutional provision that is separately enforceable as an equivalent of our Section 1. And secondly, this was a right of enjoyment of property with the consequential right not to be deprived thereof except by due process of law. In constitutional terms, this is some distance from and clearly not relevant to an interpretation of our Section 13. So, Lord, we say that Papanet can be distinguished, paragraph 28 of our submissions, Papanet can be distinguished from the present case because the issue of whether Section 4A of the Trinidad and Tobago Constitution has been breached relates to a provision that is not anywhere like our provision. The section refers to enjoyment of property and the right not to be deprived thereof except by due process of law. That right is much broader than the Section 13(1) of the Bermuda Constitution and arguably broader than Section 1C. The Court of Appeal cannot therefore assess the scope of Section 13(1) of the Bermuda Constitution by reference to Section 4A of the Trinidad and Tobago Constitution. Further, the learned Chief Justice provides 3 other cogent bases for distinguishing Papanet from the present case in paragraphs 118 to 119. I'm going to come to that shortly, but before we come to that, I'd just like to distinguish another case at tab 23 of the bundle. This is the case of the Compan Souchere. By Compan Souchere. This is the case. Now,
Yeah.
now, my Lord, if I can ask you to look at page 495. My learned friend, Sir Geoffrey read paragraphs C, D, and E on page 495. Now, I'll put it in context. You'll recall that he read those paragraphs in order to try and encourage the court to use Section 1C as an aid to interpretation of Section 13. So in this case, Section 3 of the Mauritius Constitution, which contains the right not to be deprived of property was used to interpret section 8.1, the more specific property right. Lord, that case can be distinguished and not fancifully, but importantly in constitutional terms, because this is a case from Mauritius. Section 3 has its own separate enacting force. And as we've seen from the cases of Olivier, Campbell Rodriguez, and Newbold, constitutions such as the Mauritius Constitution and its import and effect are to be distinguished if the Section 1 equivalent is an enacting provision, which it is in this case. So we say that this is a Mauritian case, Section 3, it's an enacting provision. There are therefore the arguments as to how this case and its interpretation of Section 3 could assist an interpretation in our case of Section 13 are irrelevant, we say, and we'd ask the court to disregard the case. So, my lord, paragraph 30, well, we say that on a reading of the judgment of the Chief Justice, this court should uphold his findings because they were consistent with the authorities that bind both the Supreme Court and the Court of Appeal, namely Panton and Campbell Rodriguez. They properly assessed the nature of the control issue, and the Chief Justice, in relying on them, arrived at what we say was the correct decision. And we'd like to take you to his judgment and the portions of his judgment that we say should be upheld on this appeal, starting with paragraph 98. And we say that when you read the learned Chief Justice's judgment in extensio, not only can you see how he properly applied the authorities on Section 13, he dealt with the independent enforceability point, he dealt with the control issue, and he dealt with the reference to cases that were inapplicable in the Bermuda context. Lord, paragraph 98, as noted at paragraph 43 above, Section 31 provides that no property of any description shall be compulsorily taken on, and that no interest in or right over property of any description shall be compulsorily acquired, except in the circumstances set out in sections A to D. In considering the scope of 13.1, Mr. Deal for the corporation admits that in Inchcup, the Court of Appeal gave a very restrictive interpretation of these provisions. The court drew a distinction between the concept of deprivation in Section 1 and taking into possession or acquisition in Section 13, in language clearly suggesting the court's view was that in order that there be a taking into possession or acquisition, there had to be either a direct appropriation of the property or an ouster of possession and a transfer of change of ownership of possession from one person to another person or body. The relevant passage referred to, paragraph 14, I'm not going to read that, Lord, if I can go over the page. And then, my Lord, I'm not going to read that also. You see, that's the paragraph where the concession is that I've been referring to in our skeleton submissions. And then you see that Mr. Deal submits that the Inchcup has been entirely overtaken by Campbell Rodriguez, and the court should apply the reasoning in Campbell Rodriguez to this case. And you'll see in paragraph 101, there is an attempt to try and suggest that the equivalent of our section 1 was independently enforceable. Then towards the end of that paragraph, the Privy Council confirmed there could be taking which did not involve the physical appropriation of property or any ouster of possession. In that regard, relied upon by analogy the United States cases dealing with regulatory control of property which adversely affects the owner to a sufficiently serious degree. If the regulation goes too far, it will be recognized as taking, if it being a question of degree. Lord Cardwell also held at paragraphs 15 and 17. I'm not going to go over those, but again, you see the reference to the Chief Justice saying if the regulation goes too far, it will be recognized as taking, if it being a question of degree. Then if I can take you over to paragraph 102, taking by regulatory control has its limits. Regulation of activity in the public interest, such as planning, control, or the protection of public health, will not constitute taking of property, notwithstanding the fact that they may have an adverse economic effect on the owners of certain property. And then they refer to paragraph 18, where Lord Carswell refers to, in Campbell Rodriguez, where Lord Carswell refers to Panton. We've read that already. Paragraph 103, in light of the above passages from the judgment of Lord Carswell, I accept that in principle, there could be taking by regulatory control, despite the restricted terms of section 13.1 of the Constitution. And then there's a reference to the United States cases referred to in the judgment in Campbell Rodriguez. And there's a reference to Lucas in paragraph 105, Penn Central in 106, and Pennsylvania, which my Lord President referred me to in 107. Then we go to 108. The facts relied upon by the corporation in support of its claim for deprivation of property are set out at paragraph 44 above. But we have seen that the corporation as an entity remains in place and continue to own its property as before. The regulatory control complained of does not directly affect the property owned by the corporation. What is complained of by the corporation is that essentially every decision made by the management of the corporation has to be approved either by the minister or by the cabinet. Furthermore, under the proposed Reform Act, the minister and councillors are appointed by the minister or by a selection committee appointed by the minister. It is said that the effective management of the corporation lies and would lie indirectly with the central government, as opposed to by the independent management comprised of the mayor and councillors elected by voters of the city of Hamilton. The main case relied upon by the corporation in relation to its allegation of regulatory control is the decision of St. Christopher Attorney General versus Lawrence. And then it sets out the facts of Lawrence. And then in 110, as a result of these actions, Mr. Lawrence ceased to be a director of the page. And then 111, my lord, relying upon Lawrence, Mr. Deal argues the effect of the Amendment Acts and the proposed Reform Acts is in effect to remove the current independent management of the corporation by elected mayor and councillors and replace them by persons selected directly or indirectly by the government. He submits that the position of the corporation is on all fours with the facts, and that holding of the Court of Appeal in Lawrence therefore applies. The issue whether taking control of the management of company amounts to taking of property of the company was addressed by the Privy Council in Panton. And we've got the facts there. And then going over the page, paragraph 113, the Privy Council did not accept that the mere taking control of the management of a commercial enterprise amounts to deprivation of property of the owners of that enterprise. And we've read paragraph 22, Lord Clyde. And then this is the Chief Justice's reasoning, paragraph 114. In Panton, the appellants expressly relied on Lawrence and argued that Lawrence was an authority for the proposition that mere control of the management of a commercial enterprise amounted to taking of property. That point was expressly rejected by the Privy Council, and Lawrence was distinguished on that basis, on the basis that Mr. Lawrence not merely lost control of the management of the bank, but lost the prospect of obtaining up to 50% of the profits generated by the bank. It was the loss of profits which amounted to the taking of property. And at paragraph 22, Lord Clyde held, and we've read that already, my lord. And carrying on with the Chief Justice's reasoning, paragraph 115. In my judgment, Panton, which is binding on this court, is authority for the proposition that mere loss of control, even total loss of control, does not amount to deprivation of property. There must be taking by reference to the loss in value of identifiable property. This was the basis upon which the Privy Council distinguished the decision of the Court of Appeal in Lawrence. Here, the corporation as a legal entity continues to own the assets as before, and there is no suggestion there has been any diminution in value of those assets. And we commend that reasoning to the court. Mr. Deal for the corporation also relies on Papanet. The appellants were members of an association. We've had those facts. And if we turn over to page 11, paragraph paragraph 119, the Chief Justice says, and we can distinguish Pampanet based on the reasoning that I just submitted to the court, but factually, the Chief Justice said in paragraph 119, the facts in Pampanet bear no relationship to the allegations of existing control and proposed control of the corporation's affairs made by the corporation in this case. None of the three factors in the Pampanet case mentioned in the previous paragraph, which formed the basis of the finding there was a breach of Section 4A rights, were present in this case. Well, Lords, I've done you a disservice. I apologize. If I can go back to paragraph 118, just so that you can understand the Chief Justice's reasoning. Halfway down the paragraph, beginning here, the interference with the business of maxi taxi owners and operators was substantial. This is the Chief Justice's assessment of Pampanet. First, they had previously managed and controlled their own affairs, but now they were subjected to the control and management of their competitor. Secondly, pursuant to the authority conferred by the regulations, the competitor charged the maxi taxi owners and operators a fee for every exit journey. And thirdly, under the regulations, the competitor decided whether the maxi taxi owners and operators were fit and proper persons to be granted a permit to use the facility at all. In the circumstances, Lord Dyson held prima facie there was an infringement of the members' Section 4A rights. The three factors identified by Lord Dyson clearly had significant negative impact upon the maxi taxi business, being property within the meaning of the Constitution. And then the Chief Justice says, the facts in Pampanet bear no relationship to the allegation of existing control and proposed control of the corporation's affairs made by the corporation in this case. None of the three factors in the Pampanet case mentioned in the previous paragraph, which formed the basis of the finding that there was a breach of Section 4A rights, are present in this case. The allegations of regulatory control made by the corporation in this case are very much in line with the allegations made in the Panton case. And then finally, at 120, the corporation's challenge based upon deprivation of property contrary to the constitutional right under Section 13(1) of the Constitution is based entirely on the basis of control exerted by the central government over the affairs of the corporation. The corporation accepts that this is not a case where there has been any transfer of property from the corporation to the government. The Privy Council decision in Panton clearly holds the assumption of management and control without more does not amount to deprivation of property. Significantly, the Privy Council in Panton distinguished Lawrence, the main case relied upon by the corporation, on the basis that the loss of property in that case could be identified, loss of up to 50% of the dividend from the bank. In the circumstances, I'm satisfied that the corporation's challenge based on Section 13(1) of the Constitution cannot succeed. So, Lord, that is the basis upon which the Chief Justice dealt with the Section 13.
Yes, could you just help me with two passages? If you go back to 103,
103.
Having referred to various cases, he says, in the light of the above passages, the judgment of Lord Carswell, I accept that in principle there could be taking by regulatory control, despite the restrictive terms of Section 13(1) of the Bermuda Constitution. So in principle, there can be there can legitimately be a taking by regulatory control, which wouldn't come within the Constitution. And then at 115, having gone through various other authorities, he says, in my judgment, Panton, which is binding on the court, is authority of the proposition that mere loss of control, even total loss of control, does not amount to deprivation of property. There must be taking by reference to loss in the value of identifiable property. But assume that the minister says you can't use a building at all. You're not simply not to use it. There's some municipal building. And assume that that can't have been regarded as some aspect of regulatory control, but the order was made for some not very clear reason, but was made nonetheless. That would appear to me to amount to a total loss of control to the relevant building. And I don't quite follow why that wouldn't amount to deprivation of property. If I say you can't use your building, you are deprived in effect of your property. And I can't see, and that would be, I would have thought, a reference to loss in the value of identifiable property. I quite understand the distinction between taking by regulatory control and taking otherwise than by regulatory control. But what I'm finding some difficulty with is where is the proposition that total loss of control doesn't amount to deprivation of property?
Well, I suppose Panton is the answer for that, because in Panton, the regulators went into the bank and took control. I mean, maybe we should go to Panton just to make sure that.
Did they do that as a regulatory matter?
Well, let me make sure that I characterize the invasion of the rights in Panton before I make a submission on it. But let's have a look at Panton.
Yeah, well, I've forgotten the page at the end of the tab.
It is
Tab 49.
Thank you.
So that's Papanet.
Oh, I'm popping in, I'm sorry.
Yeah.
Oh.
48. It's at 48.
Yeah.
So, my lord, if we go back to page 132, we see the factual matrix. The Minister of Finance and Planning assumed temporary management of the three institutions under Section 25. The appellants commenced proceedings claiming that the provisions of the 1992 Act and consequently the actions of the minister were unconstitutional since they amounted to compulsory acquisition without compensation of a right protected by Section 18. And then
then if we go to the holding at paragraph 3 of the head note,
yes,
going from B, well, the appellants had to show that the action constituted a taking of their property. What the minister did was to take over control of the company. Appellants remained shareholders and none of their property had been taken away. Equally, no one had been dismissed, and thus no one had property taken in the sense that they were removed from office. Ultimately, the statutory provisions were regulatory rather than confiscatory, and therefore no obligation to compensate arose.
and that's explained at paragraph 22, my lord.
Yeah.
See, my lord, and this is where there may be a distinction between the wording in the Bermuda Constitution and the wording in the Mauritian Constitution, which related to enjoyment of property. There is a distinction between a taking and the enjoyment of, which is wider.
Sorry, which constitution has enjoyment of?
We saw that in
Mauritius, was it?
yeah, it was Mauritius. It was the Mauritian
Yeah.
constitution, and that was
But it's not Jamaica or Bermuda, is it?
well, actually, in Campbell Rodriguez. Look, before you turn there, let me just make sure before I put you through the trouble at tab 14. Let me just check. In Campbell Rodriguez. Campbell Rodriguez, I think that there was a reference to enjoyment of property.
Yeah.
But what we say is that on a plain reading of the authority pattern, they are talking about, in paragraph 22, an actual taking or an acquisition. The example that the Lord posits is more in the scheme of an enjoyment of property rights. And that is not what is constrained under the Constitution.
So the preventing use falls within enjoyment of property rights
Well, yes.
and isn't to be regarded, if you prevent somebody from using it at all, that isn't to be regarded as an acquisition of an interest in property.
According to Panton, no. Well, yes, that's correct. Because if you think about it, the directors and the managers were displaced. And in a constitution similarly worded to ours, it was said that what the powers and what the minister did was a taking over of the control of the company. The appellants were and remained
In Panton, there were the shareholders and none of the shares had been taken. And no one had been dismissed.
That's correct. But the management and control had been assumed.
Yeah, well, I can see that in those circumstances, there's no acquisition of an interest in property. But what I'm finding more difficult is if somebody who has an interest in property in the sense that it's his property and he's entitled to use it, how it can be said that there hasn't been an acquisition of an interest in property if he's told that hereafter he can't use it.
Well, our first submission would be the constitutional protection seems to relate to a taking and acquisition. Our second
wait, pause there. Go back to where I was before. The constitutional provision doesn't refer to a taking and acquisition of property. It refers to taking possession and acquisition of an interest in property.
Yes. Yes, no.
I mean, all the cases seem to use the expression taking in relation to constitutions which only use taking by reference to possession. And they don't use, although the constitutions contain the words, acquiring an interest in.
Lord, and the reality is that if the court is going to assume that this factual matrix fits within acquiring an interest in, and we say it doesn't, there's no evidence in this case to suggest it does. We're again posing hypotheticals based on what could take place. We have to interpose, first of all, the section 13A to D defenses. And secondly, again, it would be a matter of degree, which is why it's difficult for this court to make a pronouncement on it now. it may be that it's one room. The government say you can't use one room. We need it for storage of government photocopying files from past cases. It may not be the whole building. It's difficult for the court at this stage to make pronouncements on exactly what degree of taking is within or without the constitutional protection, particularly in light of all the submissions I've previously made about how the provisions applicable to the minister giving direction should be interpreted.
Okay, thank you.
So, my lord, I think that now I can turn to the point that
we're back to freedom of expression.
yes, my Lady Gloucester has been asking me to address.
Yes, well, we'd like to know what the answer to that is.
I can say the first point, my lord, is this. Turning to the case that my learned friends rely on, it actually doesn't help them. It hurts them. And the reason it hurts them, if you turn to it, is this. Before I even get into the body of my submissions, if we turn to the Bermuda Telephone Company case, this case is of no assistance to them and in fact supports our submissions.
Moment. Well, I'm afraid it's completely disappeared from the cloud, so far as I'm concerned. Yeah, you better go on without me, but it's what has happened is that EF square to the left of the address of the name of the case is now completely blank. So I'm incapable of accessing it.
I'm sorry, what is the reference?
It's in additional authorities submitted on the 15th of November. And when
Which is the one that I found I couldn't download anyway.
Right.
My lord, well, I'll deal with my point and I'll come back to it. But the reason I address it directly is firstly because I think this point has animated the court. And secondly, in the email I got from Mr. Coelho, it was specifically referenced. The email I have reads further to my email below. This is Coelho to all the parties. The court is currently minded to consider the contention of the Corporation of Hamilton that the proposed Reform Act infringes Section 9 of the Constitution insofar as its purpose and effect is to stifle the opinions of the electors by removing their opportunity to express their views through the regular elections. It does so on the basis that the public order exception in Section 9 is as stated by Huggins, J.A. and Bermuda Telephone Company and the Attorney General. It is, of course, open to further submissions on the latter point on whether it should address Section 9 at all. So that's the reason why I went to the case. If the court needs time to...
wait a moment. Wait a moment. Mm. Yeah, I have in fact got it, because when it was on the cloud, I printed it out, no doubt wisely, fearing its disappearance, but I'm not sure that my colleagues.
I don't have it.
I like you, Christopher. I'm sure I got it earlier, but I didn't print it out. And
Mm.
now it says failed to load and I can't download it.
Yeah. Well,
But I did have it earlier. That's what's so mysterious.
that's what drives one absolutely mad. But
My lord, I can continue and make my point and come back to it if need be.
well, I think one. Oh, I see. Okay. I mean,
Why can't we have a version that can go on the cloud? So that was addressed to you, Mr. Duncan, or perhaps to Mr. Coelho.
My lord, it's not my case. I
No.
don't know. This was a case relied on by Mr. Sir Geoffrey and Mr. Myers, so I don't know.
yes, I mean that case was relied on because the submissions that were made to us earlier in relation to Section 9 is that the facts of this case, leaving aside all question of motive, came plainly within Section 9, and the only possible exemption was if it could be said that the inhibition on public expression was in the interest of public order. That's what the case relates to. And since that was the position last week, the email that I caused to be sent was to the effect that we would consider whether or not the Section 9 case was well-founded upon the footing that the exception that was sought to be relied upon was the interests of public order, and upon the basis that, as this case held, went to matters such as breaches of the peace and other such matters. What has now happened, as this case develops from day to day, is that you don't rely on the interests of public order. So whether or not public order extends to only to affray or further is not something we have to determine.
No, my lord, but what the case is instructive for is the legal and procedural conundrum that the appellants seek to put you in.
Oh.
And the reason I say that is because one of the most instructive points in the case, and you can take a note of this, is on page 6 of the case. Yes, there was a reference to public order, but the party relying on public order was given a right to rely on it and file evidence in the Supreme Court. That's not something we're being given in this case. The constitutional framework for all of the Bill of Rights provisions, or a significant number of them, are structured in a way that the court is well aware, probably better aware than I am, namely that the right is afforded, the claimant of the right asserts a hindrance, the government is then given an opportunity, a mandatory opportunity, to show whether or not the enactment or the provision is reasonably required on evidence. If the government satisfy that burden, the burden then shifts back to the applicant to show that that particular provision is not reasonably justifiable in a democratic society. What the appellants are doing is they are starting the process in the appeal court and depriving the respondent of the fundamental obligation they are entitled to adduce evidence as to whether or not the provisions are reasonably required. And it is procedurally and legally wrong.
Yeah.
This point can't even, that's the most instructive thing in the case they rely on, that in the Supreme Court, the judge adverted to the issue of public order And that was the basis upon which the Court of Appeal could then make a determination as to whether or not public order was something that was a reasonably requirement in relation to the provision. So, I mean, we'll go through these submissions, but we say it will be a travesty if this court determined that it was going to prohibit the government from having any opportunity to file evidence on a defense, make a determination. And not only that, my lords, not only, it gets worse. The court is obliged, and I will take you to the authorities, to look at the evidence that the government files and afford the government a margin of appreciation and weigh that balance. And what this does, bringing this point now, not only does it rob the government of the opportunity to file evidence, it robs you, my lords, of an opportunity to determine whether the margin of appreciation or the margin of judgment is balanced in favor of the government or the public. And we say that for that reason, this section 9 point is, it really is a point that should not even be entertained. But we'll go through the submissions, paragraph 31.
Right.
The background to this issue is documented in Trott and Duncan's letter dated the 22nd of October. In that letter, you'll recall, we had leveled criticisms at the piecemeal manner in which this argument has been raised. The point does not occur below, nor in the notice of appeal. It appears for the first time in the appellant's Court of Appeal submissions, and in particular, paragraph 145. And they state, to be clear, it is not here asserted that under the terms of the Constitution, there is a right to local government. And that's going to be another important point we make because the authorities advert to that, or a right to the democratic election of a local government corporation sole. Our submission is that the contravention of the Constitution lies in the removal of an extant democratic mechanism on the ground that its decisions and opinions have offended or are likely to offend an opposing party now in government. It is an attempt to stifle dissent, which significantly impedes the marketplace of ideas that underlies the principle of free expression, which is the cornerstone of any democratic society properly so called. Then the supplementary notice recasts the position. The proposed Reform Act infringes Section 9 of the Constitution, being an unjustifiable and disproportionate violation of the right to free expression, in that it purports and its purpose and effects are to stifle the opinions of the electors and of the Corporation of Hamilton by removing their long-standing opportunity to express their views through regular elections of members of the corporation. The summons simply seeks permission to rely on the freedom of expression point in the terms of the appellant's Court of Appeal submissions.
Well, just pausing there for a second. If one takes paragraph 33, the second sentence says that the submission is that the contravention lies in the removal of a democratic mechanism on the ground that its decisions have offended or are likely to offend an opposing party. Well, Sir Geoffrey's indicated that they're not proceeding on, for present purposes, on the basis of motive. So that comes out.
Yes.
And if the position is that it's not asserted that under the terms of the Constitution there is a right to local government or a right to the democratic election of a local government corporate sole, if there isn't such a right, it's difficult to see how refusing a democratic election is a breach of any constitutional right, since the right doesn't exist.
It doesn't, Lord, and indeed we will rely on the European Convention cases that actually deal with a different protocol or constitutional equivalent, but they explain the rationale for the reason why there is no right to local government protected at the constitutional stroke ECHR level, which is why they've brought no cases to show that, because it doesn't exist. And I'll come to those shortly, my lord. So we say in paragraph 36, in response to these arguments, the appellant has maneuvered yet again and say the removal of the right to vote for members of the appellant ipso facto infringes the freedom of expression in section 9.1 of the Constitution, but is unclear as to whose right to freedom of expression it infringes. First, the respondents challenge the appellant's standing in terms of both section 15 of the Constitution and whether the appellant's freedom of expression rights have been hindered within the meaning of section 9.1. The fact is the mayor and councillors may well be electors, but they are not parties before the Court of Appeal in such capacity. The only party before the Court of Appeal is the corporation, a body corporate with powers limited by statute. There is no suggestion the corporation's right to freedom of expression has been infringed in its corporate capacity. Paragraph 38, in any event, we submit any such submission would be unsustainable. The appellant will be able to freely express itself after the reform bill is enacted. The appellant contention can only be that the specific opinions, which is what they're now disavowing, my lord, held by those that comprise the appellant for the time being are being hindered. That's, my lord, that is the real vice. And that's why they are jockeying backwards and forwards as to whether or not it's the mayor and the councillors or the electors or the corporation. They're trying to find one that fits. The reality is the party before the court is the corporation, and their freedom of expression rights have not been infringed. Secondly, we say the right to freedom of expression in section 9 of the Constitution is not an unqualified right. If the appellant is allowed to proceed, the respondents would be deprived of an opportunity to adduce evidence that falls within section 9.2 of the Constitution. In particular, that any hindrance on the right of freedom of expression as a result of the reform bill is reasonably required for the purpose of protecting the rights, reputations, and freedoms of other persons. And that's in section 9.2a1 of the Constitution. The fact is, and that's the point I made before, and that's the real benefit of the authority, the Bermuda Telephone Case Authority. It demonstrates that at first instance, there was an opportunity for the government to provide evidence. Whether they took it or not, it's not a matter, but they had that opportunity. Paragraph 40, the fact is by removing municipal elections, the entirety of Bermuda gets a voice in who comprises the corporation. In that sense, the reform bill provides more people in Bermuda the right to exercise freedom of expression in how the appellant is managed by their voices in national elections. The elected government would then appoint the relevant minister, who would then appoint the mayor and 4 councillors. The effect of the reform bill, therefore, protects the rights, including the freedom of expression rights of those that are not residents or business owners in the city of Hamilton. But
the entirety of Bermuda doesn't appoint the minister. I don't think you get that.
My lord, that isn't what I'm saying.
You say the entirety of Bermuda gets a voice in who comprises the corporation.
Of course, my lord, that's our submission, they do. And the reason that's our submission is because they vote in an election. That election creates a winning party of whatever complexion. That party, through the constitutional arrangements we have, selects ministers to carry out certain functions.
By which time the voice of the electors has gone. They've done their part by electing their parliamentarians. The party with the most parliamentarians gets to form a government. Premier gets to appoint ministers. But the entirety of Bermuda doesn't undertake that function.
Well, Lord, the entirety of Bermuda was a reference to the fact that the winning party has the right to select the government that selects the minister that will control this process. That's the democratic.
That I understand and don't dissent from. But you say in that sense, the reform bill provides more people in Bermuda the right to exercise freedom of expression.
Yes, my lord. I mean, the reality is in paragraph 41, we say, put another way, had the legislature extended the vote in the municipal elections to the entirety of Bermuda, there could be no objection. And
it's the difference between the direct and the indirect that I have a problem with.
well,
I mean, if, as you say, all residents of Bermuda could vote in municipal elections, that would be a direct vote. What is proposed under the reform bill is indirect insofar as they vote for the party which ultimately forms the government, appoints ministers, so on and so forth.
I accept that, my lord, but what we have is a situation where the respondents have not had an opportunity to file evidence to demonstrate that that's what the people want.
What evidence could you file?
Well, Lord, if you look at paragraph 42, you see there's a reference to the evidence of Mr. Rochester.
Yes.
Paragraph 42 of the skeleton argument, see a reference to the evidence of Mr. Rochester. And what Mr. Rochester says is the Municipalities Reform Act and subsequent amendments to the legislation establishing the Corporation of Hamilton, the Corporation of St. George's, have been aimed at improving governance, providing for representation of the wider community in municipalities that have within their boundaries among the most important infrastructure in Bermuda, where most Bermudians work and work permit holder work, but do not live. The purpose of the change is to have an effective governance of municipalities in the public interest for the good of all Bermuda, my lord.
So you would seek to put in evidence challenging that?
Sorry?
You would seek to put in evidence challenging that?
No, what I'm saying is...
Rely on it.
No, what I'm saying, my lord, is that had this point been taken down below, we would have had the opportunity to file evidence from members of the community who support that, reasons why it is in the interests of this country for that to be the case, how that would protect the rights and freedoms of others, and then the court would have to apply the margin of appreciation and judgment to that assessment before it arrives at a decision.
Right.
This court can't do that. We've been deprived of that opportunity.
Mr. Duncan, I understand your argument, your submission that you've been deprived of the evidential opportunity. What I don't understand, and I think I'm putting the same question to you as Lord Justice Bell did, what I don't understand is how it can get any better than the recital to which you've just referred us. I mean, can't get any better than that.
Yes,
the reason why this bill is being preferred is because or being proposed is because the proponents of it think it's in the interests of the whole of Bermuda that the municipality should be deprived of the vote of appointing their mayor and corporation, and that government should set up an institution that does so.
Lady, I asked...
It can't get any better, can it, than what's in the bill? You don't need any evidence. We've got to take that as a given, haven't we?
No, my lady, I ask not rudely and not rhetorically, but how do you know?
Well, we can assume that. We can assume.
But my lady,
that is the view of the proponents of the bill.
But my lady, the margin of appreciation is to be assessed on the quality of the evidence.
Okay, I've made the point. I don't want to argue with you.
Well, it may be less clear than that. The question under this exception is whether the reform bill is reasonably required for the purpose of protecting the rights, reputations, and freedom of other persons. If there was only one person in Bermuda who thought that it was sensible to change the way in which the council was appointed, it would be rather difficult to say that the change was reasonably required for the purpose of protecting the rights and freedoms of others.
We can't conduct a vote, can we? And we can't receive evidence as to how many people would vote one way and how many would vote the other.
Well, we could receive evidence as to what is the strength of views on this point?
Sorry, can I interrupt again? Because in fact, I think I can help. There is such evidence already. The government conducted a survey and there was lots and lots and lots and lots and lots of responses, all of which said, we don't want the government to touch the corporation. So if we're going to take that into account, it's the people saying, we don't want this. I mean, I don't know what my learned friend, what other evidence he thinks he's going to get by retaking another survey.
Lord, I hope I get the same latitude to intervene in my friend's submissions when he replies.
Yes, yeah, I think you probably should take it since.
Sorry, Lord?
I think you should probably take it since you've been interrupted. Abandon your normal courtesy and interrupt when you think fit.
I'm obliged. But my Lord, going back to the point, this court, let's reel back a little bit. What this court is going to have to say is we acknowledge that the Section 9 point was not taken in the Supreme Court. We acknowledge there is some evidence that supports the exception in Section 9(2)(a). We have formed the view that there could be no additional evidence that could support the contention the government may wish to make. And we have formed the view that we can balance the exercise of the margin of appreciation, and we will make that decision now, despite the fact the government have not had the opportunity. Well, lady, if that's what the court intends to do, I can't gainsay that, but I say that that is a very unsound approach to take in constitutional law when you're balancing the rights of the people against the government. I think that the concern I have here is that the impression is that the balance is between the corporation and the government. That's the margin of appreciation balance that is in effect. The reality is that the government, through the democratic process, is given the right to balance the interests of the community as a whole. And so what this court is saying is, we are going to take away that opportunity to hear the evidence, to balance the rights of the community as a whole, and take away the opportunity for the government to flesh out this evidence. What the court has to realize is the reference in Mr. Rochester's affidavit wasn't made for the purpose of addressing this point.
I follow that because the point wasn't lied.
No.
It wasn't made for I've not even been able to take instructions as to what other evidence could have been filed.
What do you say to Mr. Meyer's point that the evidence is in fact in through the survey?
Not all the evidence. Again, we're making assumptions as to what the evidence is. And if the court is going to say we are in a position to arrogate to ourselves what a government would do when it comes to evidence, then I can't gainsay that. There's no argument I can have against that. All I can say is it goes against all sound constitutional principle and interpretation. It really does, because governments are to be given a wide margin of appreciation. I'm going to take the court to those authorities. So at least they're on record if the court takes the view that it wants to make a determination on the appellate level without the government having the opportunity to address this at first instance. I will, I think, take the court to those authorities. I was at paragraph 40, which I think I've already made that point in another way. And I think that I've already heard the court don't believe that that's a direct involvement of the electorate. But anyway, the fact is that by removing municipal elections, the entirety of Bermuda gets a voice in. And actually, I think I did go through that paragraph. And I'm now on paragraph 43, I'm reminded. So The respondents have been deprived of the opportunity to provide evidence to support falling into section 9.2a of the Constitution. It should be further noted that the above is fundamentally a social and macroeconomic issue. As such, in applying the reasonably required in section 9.2 of the Constitution, the legislature should be afforded a wide margin of appreciation. This was confirmed by the Privy Council in the case of Timberland. Can I take the court to the case of Timberland? Lord, if I can ask you again,
Where do we find it, Mr.
it was a case that was provided this morning with the additional submissions.
Right. So when I got those additional submissions, I didn't print off the case. Is it now on the cloud?
Yes.
And where is it on the cloud?
It's under additional submissions of Duncan QC 2021-11-17.
I see additional authorities. What's the particular heading?
It's the fourth subfolder, further submissions by Duncan QC.
Right.
Yeah.
I fear that the problem is I'm not going to be able to open any of these.
I'm sorry, my Lord Bell.
But let me just try.
Fifth one down.
Fifth one down. Let me go back. I have it. Thank you. Sorry for that.
Yes. Do you have it now, Malone?
I do, Mr. Duncan. Thank you.
Yes. Lady Gloucester, do you have the case as well? Yeah, you do. I think you're on mute.
Yes, I do have it. Thank you.
Right. If I can ask the court to turn to paragraph 38. Paragraph 38. As to the nature of the issue involved in this case, the 2000 Act was a measure of social policy with significant macroeconomic implications, and particularly bearing in mind the specific criticisms advanced by the claimants with considerable budgetary implications for the government, which are anyway engaged, not least because of the tax foregone on contributions to the scheme, whether to introduce such a scheme, and if so, what its general terms should be, and in particular, whether they should include a guarantee entrenchment or early withdrawal rights, are by their very nature decisions as to which the court should afford the government a generous margin of judgment or appreciation. When it comes to policy changes of a social and macroeconomic nature, the court should be particularly diffident about interfering, given the nature of the functions, expertise, and experience of the judiciary as against the executive, or in this case, the legislature. And then in the Great Bay case, which is at 54D. Great Bay case, 54D. 54D.
Wait a minute. Is this Great Bay in the Privy Council?
It is, my lord. Great Bay in the Privy Council, 54D.
Yes.
Paragraph, page 585, paragraph E.
Yes.
That in the joint authorities bundle?
It is, my lord. I think this was
Yes.
submitted by my learned friends as an additional.
I'm sorry, Mr. Duncan, it's my fault for taking so long. 54D, I have it.
54D, page 585.
Well, I can't find it, I'm afraid. You better go on without me. I can't find it on the cloud at 54. Yes, I've got it now. I've got
Yeah,
it
it's
now.
in there.
I've got it now.
I
You
can
just have
say-
to upload it.
If Milady can't find it, then I couldn't have found it. So if I can find it, Milady.
No, I can find it. I've got it now. What page again, please?
585.
Thank you.
Lord President, do you have it?
Yes,
do?
because I fortunately printed it out.
Right. So starting in the middle of D to give the paragraph some context, the unique identity of Bermuda, which as the background shows, it was the object of legislation to preserve, may be a somewhat intangible concept, not easy to reduce to a few propositions, but feelings about what gives a community its identity are powerful and important. The issues which they raise are preeminently matters of democratic decision by the elected branch of government. The members of the legislature are not required to explain themselves to the judiciary or persuade them that their view of the public interest is the correct one. The Lordships note that in the Court of Appeal, Kempster J. commented that the legislature, rather than the courts, is in the best position to assess the requirements of the public interest and should be allowed a wide margin of appreciation. So what I say is not that the courts can't assess that, but the reality is that the evidence hasn't been provided, or at least the government haven't been given an opportunity to provide that evidence upon which the first instance court could have made that judgment, as was the case in the telephone company. And then the Court of Appeal can exercise some judgment as to whether or not that assessment of the wide margin of appreciation was correctly balanced. In this case, we do not have that opportunity, and I submit that the court should not arrogate to itself, one, the amount of evidence that should be determined that the government would or would not provide in response to this, two, assess the margin of appreciation in the case. I say candidly, I'm not sure how the court could do that with the evidence that we have at the present time. Lord's paragraph 44, the Privy Council authority of Timberland was affirmed in the Supreme Court in a case called Ackroyd. Ackroyd is a case that I provided to you today. And Ackroyd, I see my Lord Justice Bell smiling. Maybe there's something I've missed with that case.
I'm just smiling at the possibility that I can now find it, but tell me where I can find it on the cloud, Mr. Duncan, because I did, or is it just in email?
It's just, it was sent this morning, if that
Yes,
helps.
so Mr. Quello can tell us whether it got on the cloud or it's just in email
Yeah,
form.
it's the same number, the fifth subfolder.
So we go back to, we can get back there.
Yeah, yes.
Lord, if I can ask you to turn to paragraph 73 in that case.
Sorry.
Can you give me the name of the case again, please?
It's Ackroyd versus the Attorney General and Tax Commission.
Thank you. Thank you.
And maybe Mr. Quello can help me in terms of where I find that on the cloud under the
If you're in the subfolder
5.
called further sub, yeah, in the fifth subfolder, it's the first authority at the top.
It's the further submissions.
No, I haven't got that.
It's in the submission of further submissions by Duncan QC.
Right.
And if you go into that subfolder, into the subfolder, I've got it at the top. And you have to download it.
Will everyone be kind enough to carry on, and I will get there later.
I think the only relevant paragraph is the one that is set out at paragraph 44.
That's correct, my lord.
Yes.
We needn't actually look it up.
Yeah,
Right.
that's correct. So the Supreme Court reaffirmed the position in Timberland and endorsed the proposition, saying, I am bound and most willingly follow the reasoning in Timberland case where the Privy Council warned against the court's interference with policy choices of a social and macroeconomic nature. This must be approached with diffidence, particularly in a case where the court is concerned with legislatures inked through a process infused with democratic legitimacy and accountability. Paragraph 45 is it is submitted the Court of Appeal is equally bound by the decision of Timberland. The extent of the diffidence will of course depend on such evidence that is not before the Court of Appeal because the point was not argued below. There is therefore no basis upon which the Court of Appeal can measure the wide interest, community factors and the rights of others in Bermuda against the rights of the appellant. Accordingly, it is not appropriate for the Court of Appeal to hear the freedom of expression argument. Over the page. Now, just, I don't want to raise the court's ire, but to go back to the point, and again, my lords, I'm speculating, but as to what evidence, what possible evidence could be adduced below, there could be evidence on the economic impact of extending the vote on the community. There could be evidence of the community interest. There could be evidence from the government as to how extending the vote would mean that they could allow a greater number of people to participate in the balance of the resources currently held by the corporation. I'm just thinking of these things off the top of my head. I haven't taken instructions. All I say is that the court shouldn't foreclose the point and come to its own determination for the government. Thirdly, paragraph 46, if the freedom of expression argument is allowed to proceed, the respondents challenge the freedom of expression argument on the basis that the reform bill does not remove the democratic election of the appellant or infringe the freedom of association of the residents of Hamilton that is exercising the vote. This is the point I think that I was engaging with my Lord Justice Bell and Lady Gloucester. That the residents of Hamilton can still vote in the national election for a party that will ultimately select the relevant minister. And that is referred to in the evidence of Rosie Azar at page 537 of the record. I'm not sure we need to go to it. Nowadays, excuse me, other significant collections of trade exist outside the municipal boundaries of Hamilton, including the businesses concentrated in the Serpentine Road area. The influence of those businesses outside the municipal area on matters of public importance is by way of vote in general elections in the electoral district in which the business owner or employee lives. The same influence will be available to residents and business owners in Hamilton should the Municipalities Bill 2019 become law. What that relates to, my Lord Justice Bell will be aware of, well aware of it, but my Lord President and Lady Gloucester may not. There is an area on the outskirts of Bermuda that is quite industrial. There are a lot of businesses there, but they are outside the remit of the corporation, and they have no vote and no say in how the corporation administers a number of the services that they get because they are just outside the boundary. It is a very significant body of businesses in what's called the Serpentine Road and Pitts Bay Road area. And what we say is that that's one of the reasons why extending the vote would allow everybody to participate in resources that affect everybody, because there are few people in Bermuda that do not have an interest in what is going on and how the life of Hamilton is run, not just those who are local electors within the city. 48, further, the residents of Hamilton can nominate individuals to comprise the remaining 4 councillors. And I've already taken the court to that schedule and the provision. So we say—
can you just go back to 46? You
Yes.
said if the freedom of expression argument is allowed to proceed, the respondents challenge the argument on the basis that the Reform Bill does not remove the democratic election of the appellant. But that's exactly what it does do.
No, it doesn't, because what it does do, well, first of all, the appellant, qua corporation, doesn't have a right to vote.
No. I assume that you're referring to the election of the members of the corporation.
Well, my lord, first of all, we take the standing point. Secondly, our argument is that that vote will be through a national election.
Well, it may be, but the present, leave aside the standing point for the moment, the present position is that there is a democratic election of the corporation by the electors of the corporation. The effect of the Reform Bill will be to terminate the democratic election of the corporation by the electors of the corporation, because there will be no electors of the corporation.
My lord, what we say, I don't want to repeat it, is that there will be a democratic process that—
Well, I follow that, but I quite understand what you say about a democratic process, because you say they can vote for the government, and the government appoints the minister, and the minister appoints the corporation. I fully follow all that. But if we're talking about the election of the corporation, it will cease. If you're talking about a democratic process which has some influence, rather remote, in the composition of the corporation, that will subsist.
It will cease. And, my lord, you know, without sounding repetitive, I know I may sound repetitive, we defer then to the right of the government to provide the evidence and for the court to weigh that and form a determination. There's no getting around that. We submit.
Could you, yeah, I follow all of that, but what is relied upon is that the effect of the Reform Act is to stifle the opinions of the electors by removing their opportunity to express their view through regular elections of members of the corporation. That's the way in which it's put in the supplementary notice. Perhaps this is a question for Sir Geoffrey, but I have difficulty in understanding how it can be said that the right to freedom of expression, consisting of the right to express opinions by elections, has been inhibited if it is not said that there is a right to the democratic election of a local government corporation.
Lord, and I'm going to come on to that point now.
Right, that's what, right, okay, right.
So our submission, and this is not in writing, but the cases are within the bundle.
Okay, sorry, got it ahead of myself. Right.
No, not at all, because you would not have known that we were going to take this point unless you went through the exercise of going back to the first skeleton argument we filed, which I'm not going to take you to. But there are references to the case of Hearst and a Polish case. But our submission is this. I'll make the submission and I'll take
Right.
the cases. Our submission is we concede that the European Convention, Article 31, Article 3, Protocol 1, contains a specific provision with respect to the right to vote.
Yeah.
That is not contained in our Section 9.
Yeah.
We accept that those cases from the European Convention set out propositions that determine the rationale for the Article 3, Protocol 1 rights applying to what they call high elections or state elections, not municipal elections.
Mm-hmm.
And that those cases support the proposition that the reason for that distinction is because at the European Court level, they understand that it is not the function of that court to interfere in the local elections, which are regulated by the state through primary legislation, but to regulate the manner in which national elections take place. But what we say is that if one is to consider the purpose behind municipal elections and the constitutional protections that exist, the constitutional protections are not designed to deal with municipal elections, because effectively what that means is that they are challenging primary legislation to regulate municipal affairs. When there are other methods by which you can challenge the decisions of the state with respect to municipal elections. So for that reason, we come to the court not submitting that these cases are of binding authority. We couldn't do that because they don't contain analogous provisions. We do rely on the fact that in paragraph 145 of the just remove that from my screen. Paragraph 145 of the appellant's submissions, they say, to be clear, is not here asserted that under the terms of the Constitution, there is a right to local government or a right to the democratic election of a local government corporation. So we say that that is a nod to acceptance of the propositions that were addressed at first instance.
Sorry, what were you reading from?
I was reading from paragraph 145 of the appellant's skeleton argument.
Yes.
The first sentence.
Yes, I think, right.
We say that that is, I said a nod, but that's an acknowledgement of the arguments that were made down below with respect to the cases that I'm about to take you to now. The first case is the case of Hurst.
Just a moment. I wrote a note of what you said a moment ago, which was that constitutional protection is not designed to deal with municipal elections, because that would mean that they would be attacking primary legislation in relation to municipal elections. And there are other means of dealing with the question. That's what my note that I made. What were the other means to which you were referring?
There could be challenges by way of judicial review. There would be public law challenges that would be available. Primarily.
Sorry, judicial review of what?
If we're taking an instance of a challenge to municipal authority, it would be by way of judicial review. So if the corporation was challenging decisions that the minister is making with respect to how an election was taking place, he could probably make a challenge by way of judicial review, but there's no provision within the Constitution that allows them to make a challenge. They would have to frame that challenge, but there is no right of constitutional protection for municipal elections. This is what the authorities seem to suggest.
Right.
And perhaps if I can go to the authorities, we can see some examples, and I can come back and probably better address any concerns the court has. So the first one is Hurst at tab 70.
Yes.
If I can ask you, I'm going to select some paragraphs that I can ask you to turn to. First, paragraph 58. The court has had frequent occasion to underline the importance of democratic principles underlying the interpretation and application of the convention, and it would use this occasion to emphasize that the rights guaranteed under Article 3, Protocol 1 are crucial to establishing and maintaining the foundations of an effective and meaningful democracy governed by the rule of law. And then there's a reference to paragraph 61 to the margin of appreciation. Well, perhaps that case isn't the most useful case. Perhaps if I can take it to the case at tab 72, which is Zareb versus Malta. And if I can ask you to turn to page 4 in that case. The applicant further alleges that the facts relied on also give rise to a breach of Article 14. The high contracting parties undertake to hold free elections at reasonable intervals by secret ballot under conditions which will ensure the free expression of the opinion of the people in the choice of legislature. And then in the next paragraph, halfway down, the court must determine whether Article 3...
I'm afraid in my tab 14 consists of...
72.
Yes. Sorry, tab 72 consists of 2 pages.
Well, yes, that's correct.
Well, sorry,
Oh, it's on page... Oh, it's 4 of 5 at the bottom of the right-hand corner. So it's paragraph 2, but the 4 or 5 is in the bottom right-hand corner. But it's paragraph 2.
Well, my paragraphs aren't numbered.
Okay. Well, there's the law, paragraph 1 is on page 3, and then over the page 2, the applicant further alleges.
Yeah. Yes.
Yes. So if I've read that first paragraph on the 2, but if we can go to the next paragraph for the purposes of this complaint, do you have that one? Yes. So halfway down, the court must determine whether Article 3, Protocol 1 to the Convention is applicable in the circumstances at issue, and in particular, whether the election at issue concerned the free expression of the people in the choice of legislature. The court observes that local councils in Malta, like Naxar, are entrusted with administrative functions with their respective jurisdictions. Their regulatory powers are defined by statute, and they remain subordinate to the central parliament. The local councils, when operating and providing local services, may only do such things as are expressly or impliedly authorized by statute or by delegated legislation. The court recalls that the former commission took the view that local authorities, by virtue of the subordinate nature of their powers and functions, could not be considered part of the legislative body. And there was a reference to an application in the United Kingdom. The court sees nothing in the powers and functions of the Naxar Council which would lead it to a contrary conclusion in the case at issue. For reasons above, the court finds Article 3, Protocol 1 is not applicable. And then the next case is at tab 71, paragraph 3. Tab 71, this is the case of Moloch versus Poland. The court's assessment, so it's, if you look at the bottom right-hand corner of the page, it's page 10 of 14, but in the body, it's paragraph 3, the court's assessment.
Yes.
The court first reiterates that the term legislature in Article 3 of Protocol 1 does not necessarily mean the national parliament. It has to be interpreted in light of the constitutional structure of the state in question. In the case of Matthew versus Belgium, the 1980 constitutional reform had vested in the Flemish Council sufficient competence and powers to make it alongside the French Community Council and the Walloon Regional Council. And then it goes on. On the other hand, the Convention August had found that local authorities such as municipal councils in Belgium, the Metropolitan City Council in the United Kingdom, and the Regional Council in France did not form part of the legislature within the meaning of Article 3, Protocol 1. Furthermore, the power to make regulations and bylaws, which is conferred on the local authorities in many countries, is to be distinguished from legislative power, which is referred to in Article 3, Protocol 1. The court notes that Poland is a unitary state and that the legislative power is exercised by the Sejm and the Senate. Moreover, local government has only those powers which are not reserved by the Constitution or statutes or other public authorities of the Constitution. The municipal councils, district councils, and regional assemblies are the repositories of powers of an administrative nature concerning the organization and provision of local services. These powers are granted by statute or other subordinate legislation which defines closely and restrictively their field of application. Consequently, the municipal councils, district councils, and regional assemblies do not exercise legislative power within the meaning of the Constitution of the Republic of Poland. Furthermore, the court notes that the legality of actions of local government at different levels is subject to control exercised by the Prime Minister and the regional governors who represent the government in each of the 16 regions. And so, unfortunately, in the case of a flagrant violation of the constitutional statute, the Sejm, acting on application by the Prime Minister, may dissolve any municipal council, district, or regional assembly. The court concludes that municipal councils and district councils and regional assemblies do not possess any inherent primary rulemaking powers and do not form part of the legislature of the Republic of Poland. It follows that this part of the application is incompatible. So, my Lord, I did give caveats at the start. I'm not saying that this is directly applicable. I don't sit here and say that, you know, this says that you cannot intervene. My argument is that by analogy, the court should analyze the nature of the constitutional protections and determine that it does not, in the circumstances, apply to local government in the way that it's being applied in this case.
So when you say it, what do you?
Sorry, I'm talking about the freedom of expression. I apologize, Lord. Freedom of expression.
Well,
So, my lord, I can see that.
well, just a second. The Bermuda Constitution does not have the equivalent of Article 3 of Protocol number 1 to the Convention.
It does not.
But
Yeah.
I follow that. Let us just look at the Convention with Article 3 of Protocol number 1. There are a number of cases of which the clearest is Malta and Poland, that Article 3 Protocol number 1 is not applicable to elections to municipal councils, effectively.
Yes.
You may have to determine in relation to any particular country whether or not what one is talking about is a municipal council or something like it, or is in effect part of the central legislature. So under the European Convention, the obligation under Article 3 to hold free elections does not apply at reasonable intervals, does not apply to municipal elections. If one goes to the terms of the protocol are helpfully set out at 8/14 of this case. The protocol provides, it's in item
B, yes.
B of the law, the high contracting parties undertake to hold free elections at reasonable intervals by secret ballot, under conditions which will ensure the free expression of the opinion of the people in the choice of the legislature. I mean, would it be possible under the convention, including Article 3, Protocol number 1, not held to be applicable to municipal elections, to say that although Article 3, Protocol number 1 doesn't apply, I'm in any event entitled under the freedom of expression provisions to municipal elections held at reasonable intervals?
Well, my lord, you could say that, save for the arguments we've made already with respect to this point.
Right, wait a minute, I wonder whether you can say that. On one view of this, these provisions, the part of the convention that deals with the holding of elections is Article 3 of Protocol number 1, which has been held. So holding of elections is dealt with by Article 3, Protocol number 1, not Article 9 on freedom of expression.
Right, yes.
Accordingly, if you don't come within Article 3, Protocol number 1, which you don't if you're a municipal concerned with municipal elections, you can't reach the same result by relying upon Article 9.
Yes.
I mean, otherwise, it doesn't matter what Article 3, Protocol 1 says or means.
Yes.
If this point is good, it's a point in your favor.
Yeah, my lord, that's why I'm agreeing with you.
Yes, you began slightly not agreeing with me, but which I was slightly surprised by.
I'm surprised by myself as well. So.
Yes, well, don't worry, we've had rather a long day. But so I mean, it's possible that one views elections as falling, either falling or not falling within Article 3, and not falling within freedom of expression, such that if you have in the Bermuda Constitution the Article 9 or the equivalent, but don't have Article 3 of Protocol number 1, you can't use Article 9 so as to procure the election, which isn't provided for by Article 3 of Protocol number 1, which in the Bermuda Constitution doesn't exist.
Yes, and there was a reference to that in the Toronto case, but I'm not going to take you to that. But there was a reference to that there because they were attempting to do the same thing. I think the court made the same kind of finding.
Wait a minute, what, is there a reference to somebody attempting to do the same thing and failing?
Lord, yes, but I think it was on appeal, it was decided on a different point. So I don't think I'm going to take you to that because it may not be binding authority.
Well, never mind it's binding authority, it might be persuasive. It's, whose authority is it?
My lord, it's the case, it's at tab 73.
Right.
Let me just make sure I have.
Do you mean that?
Sorry, my lord?
Do you mean 73? This is the Canadian case.
Yes, it's an Ontario case. I mean, Lord, this let me go to my original skeleton argument because it was referred to in my original skeleton argument. It's referred to in my original skeleton argument, paragraphs 124 through to 127.
You say your original skeleton
That's the one,
argument.
the 17th of September.
Yes.
Yeah, it's referred to there.
Is it 54 something?
124.
Lord,
54 H and G.
it's 1, 2. Let's have a look where I can find that case.
This is the case that Sir Geoffrey took us through.
Yes.
Ah, right. Yes, although it may be that it's explained more succinctly in the, let's have a look for F. Yes, yes. Lord, there is a reference. Well, yes, if you look at page 12 of 46.
Or tab 46 or?
Sorry, Lord, it's 54F.
Of
Case
what?
54F.
Of what?
It's the authorities bundle that was submitted in addition to the 2 original bundles. It's the one in which you probably have Great Bay, I think, if that helpful. Yes.
So which case are we talking about?
We're talking about Toronto City versus Ontario Attorney General.
So are we talking about that in the Supreme Court of Canada?
That's correct, Lord, yes.
Right, I've got that. I'm sorry. Yeah, I've got that. Okay, wait a moment. 54F. Well, I've got a 54, but I haven't got an F.
It's on the cloud.
Well, I've got it, I printed it out, but paragraph 54 beginning ultimately what full legal force means.
Oh, sorry, my lord, have you gone to paragraph 54 or have you gone to the
Yes.
case? Oh, I was identifying the case. I'm sorry, my lord. There's some confusion. I was just identifying the location of the case. If we can now look at page 2 of the case.
Right. Yeah.
So we see that it's the case that was referred to by Sir Geoffrey. And then on page 2, you see per Wagner, the Ontario Act, Ontario acted constitutionally. The Act imposed no limit on freedom of expression. Further, unwritten constitutional principles cannot be used as a basis for invalidating legislation, nor can the unwritten constitutional provisions of democracy be used to narrow provincial authority or to read municipalities into section 3 of the Charter. Now, section 3, let me see if I can find where section 3 is located. Well, part of the problem with relying on this case is that the constitutional interpretation is a little bit confusing because it's wrapped up in positive and negative obligations.
Yes.
And so it's not a straightforward read.
Certainly not.
It's not a straightforward read. In the court below, there was an explicit reference to the fact that set out in paragraph 126 of my skeleton argument dated 17th of September, that there was an attempt to extend the rights of freedom of expression through voting. And the court rejected that. And so, my lord, what I think I would like to do is just, rather than take up time, find the exact reference and make sure that it is not wrapped up in positive and negative obligations, and then come back to you with that. Because
yes,
I have to make sure that it is apposite and not.
Well, that would be helpful.
Yes.
But I'm bound to say that I find some difficulty in thinking that section 9 was intended to deal with rights to elect. I mean, section 9 deals with freedom of expression. And on the assumption that voting is an expression of opinion, can it be said that you're entitled to have an election from time to time?
Well, no.
What?
I would say no. I think that the reality is that you're entitled to the elections as determined by at a municipal level, as determined by the democratically elected government.
Yes. Right. Thank you.
Lord, I have not been able to read thoroughly my learned friend Sir Geoffrey and Mr. Myers' submissions. I doubt, but I don't know that I'll have any responses. For now, I'd like to stop unless I can be of any further assistance and just have a look at this and just make sure that I have nothing further to say. I doubt it, but I would like to look at it.
Would it be convenient if we took a short break in order for you to do that?
I'm seeing Lady Gloucester shake her head saying
I'm just concerned about the time. We're now
Yeah.
at 7 o'clock English time.
my lord,
And if we take a break, there'll only be effectively another quarter of an hour left in the session.
I will stop for now, my lord.
Okay. So, all right. So we'll ask Sir Geoffrey. Is that what you're
Yes, my
suggesting?
lord. Yeah, my lord, I'm trying to accommodate the court.
Yes,
time
I
that
see.
we
Okay. Right, Sir Geoffrey.
Thank you, my lord. I'm not sure what the timing is for tonight and tomorrow, but I'd like
But we're
to.
not going to, I'll tell you what the answer to that is. We are not going to go beyond 7:30 tonight. We do, however, fortunately have some time tomorrow, because the case which required a Polish interpreter, which was to be determined tomorrow, can't be determined tomorrow for absence of a Polish interpreter. There is another case which will be heard tomorrow and is due to come on before the Polish case, but we are in not as bad a position as we were, because the cancellation of the Polish case means that it's not the end of the world if the other case runs over slightly, though our intention is to complete both this case and the case other than the Polish case tomorrow.
Yes. In which case, my lord, I think within the 20 minutes that we now have, I could just possibly deal with the point on protection of the law and the rule of law. The question of the deemed directions of the corporation. And I have handed up a submission on that this morning.
Yes.
And I would now like to go through that. It begins by setting out section 7AA of the Municipalities Act. And shows there the enormous power of the minister to give directions to the corporation if he considers it in the best interests of Bermuda for him to do so, about as broad as you can get there, which directions the corporation shall carry out. So there's no discretion on their part, apart from a possibly of consultation, but if he gives directions, they must be carried out.
Yeah.
Under subsection A, any act or thing, any act or anything done by the corporation in pursuance of such directions shall be deemed to be for municipal purposes and is a function of the corporation. So what we have there is that statute, which is 1923 Municipalities Act, which sets out the jurisdiction of the corporation, confers discretion on the minister to exceed that jurisdiction. The minister—
Sorry, to do what?
To exceed that jurisdiction. So it sets out the jurisdiction of the corporation, which is corporation purpose, municipal purposes. And then that same statute confers discretion on the minister to exceed that jurisdiction. Now, there are clauses, sometimes called Henry VIII clauses, which perhaps allow the minister to add or subtract from a statute, add additional parts of the statute. But they are, first of all, very much frowned upon as being dubious from the point of view of the rule of law. And in virtually all cases, they're subject to a confirmatory procedure in the legislature. This provision is so much greater than that. It simply allows the minister, in his very broad discretion, to order the corporation to go outside of their powers, and that shall be considered a deemed function of the corporation. So it confers authority to amend the very foundation of the power that's conferred. It gives authority to actually change even the objects and purpose of the statute by the executive and without any parliamentary oversight. And this has the effect then of shielding from jurisdictional challenge on the basis of vires, both, as I said this morning, the exercise of the minister's discretionary power, and also the act or thing done in response by the corporation. To call this power overbroad is a serious understatement. And in the way the deemed purpose provision, in this way, I should say, the deemed purpose provision resembles an ouster clause, which would be enacted by the legislature, but prevents judicial review of the body in question's decision, even if the decision is outside of its jurisdiction. Now, that is what the ouster clause is, and therefore permits the relevant decision maker to define the body's vires, irrespective of that established for it by the legislature. In that respect, this deemed clause, as I will call it, allows the minister in effect to rewrite the confined and limited jurisdiction established by the statute that confers the power on the corporation and on the minister. And this, we say, is what is constitutionally offensive.
Sorry, say that again. The minister is allowed to rewrite what?
Rewrite the objects and purposes of its own of the powers conferred under the statute. I think I said which confers power both on the corporation and on the minister. It allows him to do so. And that's surely like an ouster clause.
Well, wait a minute. I'm sorry. I'm still not quite clear what you're saying.
Yeah.
The minister is allowed to rewrite the objects and purpose of the powers conferred under statute. Which statute are you? Wait a moment. Which statute?
I'm talking about the Municipalities Act. The Municipalities Act, in effect, and this has been litigated, has confined objects and purposes. They're called, for short, municipal purposes.
Yeah. You mean just a moment. You mean under the Municipalities Act, prior to the amendment which is in issue?
Prior to the amendment which is issued.
Yeah. Right, thank you.
And this permits the minister, in effect, to direct the corporation to go outside of those purposes and to do, they are obliged to do any act or thing. And then that act or thing is deemed to be for municipal purposes. And when I say it's very much like an ouster clause. Now the respondents submit that if the exercise of power goes beyond the conferred scope of the municipal purposes, well, if that's challenged, the courts will just strike it down. That's what my learned friend said this morning. They will keep it in bounds. To which I would echo your words, my Lord President. What's the point then? What's the point then? Yeah, if they've got confined purposes and they'll be kept within those purposes by the courts, what's the point of allowing them to go beyond that through, and that under the notion of a deemed purpose. It seems to me that is pretty well judge-proof. It also denies the plain meaning and intent of the deemed power provision. Absolutely plain is what it's trying to do. It's trying to say you can go outside of your jurisdiction, in excess of jurisdiction, but this is deemed to be constitutional and lawful and within your jurisdiction.
Well, it may be pointless. It may be pointless because it doesn't, in fact, achieve what may have been the purpose of the people who made it. I mean, assume for a moment that one of the purposes was to ensure that the problems that arose about ultra vires guarantees by the corporation were avoided. Assume that was the purpose. And also the problem about whether or not the corporation could pay for an aerodrome. It may be that the purpose of the draftsman was to get round the difficulties that had been caused by the decisions of the courts. But we may be in a situation where that was what the draftsman or those behind the draftsman hoped that they would achieve, but in fact it's not what they were going to be able to achieve, because in fact the court will have the power of judicial review. In that case, subject to a point I'll make in a moment, the provision of the clause may be regarded as pointless, but that doesn't mean that it's unlawful.
I'm simply reading the plain meaning of the statute, and you see there provision that is extremely broad and allows them virtually to order the corporation to do.
Wait a moment.
Yes.
That depends upon whether the deeming provision is conclusive or not. You can have a provision that that something is deemed to be something, which is not final.
Well, my lord, my submission is that the plain words of the section, that any act or thing done by the corporation in pursuance of directions shall be deemed to be for municipal purposes, is as conclusive as you can get. Can there be any provision more conclusive than that? It virtually deems any action says that. Any act or thing is deemed to be for municipal purposes. How much more discretion could you possibly wish for?
Well, you could. Well, I can think of one, which is to add the word conclusively.
My lord, with great respect, I think that's very much implied in the words. It's as wide as possible. It doesn't need those words. That word.
Well, can the court say, which is what the respondents in effect do say, that in order to comply with the rule of law or in any event, the deeming provision must be construed not as a conclusive deeming, so that somebody, although the minister requires something, and when he does it, that's deemed to be municipal, a challenge can be made upon the basis that it's not in fact municipal.
My lord, I go back to the words that any act or thing shall be deemed to be for municipal purposes.
Right.
And any act or thing shall be deemed to be for municipal purposes. There's nothing ambiguous about that. The courts may be able to, in such a situation, and this sometimes applies with master clauses, if they're not absolutely clear, the courts can find a chink of an ambiguity in the legislation and say, well, there's a presumption that you would act more or less within municipal purposes, or within accordance with proper principles of the rule of law. But the courts would not be likely, even in that situation, to second guess the decision maker on questions of policy, but only of principle and rights. But this is not ambiguous. And
But I mean,
when I
what
read
is
the
what
phrase,
does the standard ouster clause say?
the standard ouster clause says something like this provision shall not be challenged in any court of law.
Yeah. So the clause says this shall not be challenged, and the courts have interpreted it as saying, well, it can be challenged.
But then the courts have said since Anasmitic, this decision or determination shall not be challenged in any court of law. Courts have got around that by saying this determination is only a purported determination. And why is it a purported determination? Because it seeks to take the body outside of its jurisdiction, not outside of the law, but out of but here, Lord, the body is authorized to go outside its jurisdiction. Authorized to go outside of its jurisdiction. It can do anything done by the corporation shall be deemed to be for municipal purposes.
Well, if in relation to if in relation to an ouster clause which says this determination shall not be challenged, the courts have said, well, that must be interpreted as if it's a purported determination, so that the courts can in fact be a challenge in relation to it. If that's the analysis in the ouster clause situation, I don't see where there's a provision which says something should be deemed to be municipal. The courts can't also say, well, that's a provisional deeming, but it doesn't mean it's conclusively deemed. And if the court is satisfied that it isn't municipal, it will say that what's required is unlawful.
My Lord, with the greatest respect, with an ouster clause, the reason that the court has settled on this term purported determination is this. The statute gives power to build roads and not airports. In this particular case, the corporation built airports. The provision says that decision shall not be challenged in any court of law. The courts then say, well, for breach of law, maybe for mistake of law or mistake of fact, we cannot review the decision of that body. But in this case, you've gone so far outside of your given powers that we can't let you get away with that ouster clause. The courts have to intervene because you're building airports and not roads. It's so great. It's a jurisdictional error. In this case, my Lord, specific permission is given to make a jurisdictional error. The power in this case is municipal purposes. The statute provides that the minister may get them to do anything or act. And if it is way out of their powers, if it does allow for satellite travel or building of airports or whatever it might be, that is to be deemed to be within the jurisdiction. And that's the difference.
Right. Well, I think we better break there. We've had rather a long day.
I have more to go on this, but
I know. That's why I think we have to break
but I'd be very grateful.
Yeah. Okay. We'll meet at 9 o'clock UK time tomorrow. Thank you all very much.
UK time?
No, 9 o'clock Bermuda
9
time.
o'clock Bermuda time. Sorry. 9 o'clock Bermuda.
Thank you, my lord.
No, you don't have to get up at 5 in the morning. Yes. Right.
Thank you, my lord.
Thank you.
Thank
Thank you,
my
my
lord.
lord.
Thank you, my lord.
So are we all, somebody is
We still have Mr. Keynes on. He's gone.
Querio, tomorrow, all
Just
well?
1 second.